I'm just reading out the operating part of the judgment. In view of the aforesaid, the respondent authorities committed a manifest error in law in levying penalty and interest, relying on the provisions of Rules 8.3 and 8.3a of the Central Excise Rules 2002 in the absence of a substantive provisions of the Act. As such, the impugned orders passed by the Assistant Commissioner of GST levying interest and penalty on the late payment of duty, which was exempted in view of the notification number 20 of 2007 CE dated 25/4/2007, is totally arbitrary, palpably erroneous, illegal, and without jurisdiction, and hence the same is unsustainable. In view of the above, in the three writ petitions, the impugned order stands set aside and quashed. Resultantly, the writ petition stands allowed. There will be some editing, you will get it after some time.
Okay.
Yes, any mentioning?
May I please?
Yes.
I beg to mention item number 23 matter.
You are for the petition?
My lord, in this case, my lord, I am the respondent,
Yes.
and I have objection.
All right, let the matter be called out. Next.
May it please, your lordship.
Yes, Mr.
Milord,
Das.
I may be allowed to move an urgent IA on Monday, Milord.
What is the urgency, Mr. Das?
Urgency is that, Milord, we one declaration of our results. The applicants before your lordships are 8th semester students of IIT, Milord. Initially, they were sought to be debarred from appearing in the final examination. This honorable court interfered and directed the respondents to yes, deeply.
Next.
May I please, your lordship? I beg to mention item number 45 with the consent of the other side. My senior is out of station.
45 is an order matter. Please wait for your turn.
May I please, lordship? Lordship, I beg to mention for listing one WBC lordship. Matter pertains to family pension, lordship. Lordship, any date on
For what?
for orders, lordship.
For orders.
Order stage.
Next Friday. Yes.
Much obliged, lordship.
I beg to mention for listing of an IA today, your lordship, for correction of our date, your lordship.
This court's order?
Yes, your lordship.
All right.
Much obliged.
Try to bring it before the
Yes,
before
yes.
2 o'clock. Yes.
My lord, I beg to mention item number 44. The petitioner's advocate is not well.
Mr. Counsel, please do not make a mention of any order matters. Wait for your turn. This court shall accommodate
My
you.
lord, due to
This court shall accommodate you. Wait for your turn. Yes, next. Next.
The lordship, I beg to mention for listing of an WPC for withdrawal.
For withdrawal. Monday. Call the list.
May I please, your lordship?
Yes.
We have filed this petition challenging the calculation of the pension money. Here, petitioner, after finding,
Notice not yet issued. All right, I'm issuing notice. Heard Mr. S. Bora.
PK Bora, my lord.
Mr. P.K. Bora, learned counsel for the petitioner. Stop. Also heard Mr. K. Gogoi, learned additional senior government advocate.
Here is a CGC for Tezpur Central University.
All right. Learned standing counsel
CGC.
CGC Koridibo. You are appearing for.
Tezpur Central University.
So 1, 2
All the respondents.
for all.
All the respondents.
By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking direction inter alia for payment of 50% of average annual emolument last 10 months or emolument last drawn on the date of compulsory retirement. Stop. Issue notice, returnable 4 weeks. Mr. Gogoi accepts notice on behalf of all the respondents, extra copies within the course of the day, list after 4 weeks on a date to be fixed by the registry.
Bless.
Mr. Borwa? You're appearing, Mr. Borwa? Item number 5. This is item 5. None appears. When the matter is called, list after 2 weeks on a date to be fixed by the registry.
Item number 6.
Yes, Mr. Borwa.
This case is really written.
Your Lordship, here, my lord, we have verified, my lord. Both the petition.
Why are you not allowing the petitioner speak?
No, my lord. They are illegally appointed teacher, my lord. So we need some time to verify whether they will get the
Yes, Mr. Borwa, what is your case?
The case is
no, my lord. They are appointed.
Why are you obstructing the petitioner to speak? You wait. Yes.
case is regarding the petition under the teacher, retired assistant teacher. The Lordship can earlier order.
Time was given for
And
instruction.
by first order is Lordship reflected on the petition as a regular teacher. They are regularized. And thereafter, only today's fixed. For the
Notice has not yet been issued.
No. Because of the fact that
You are appearing for?
I'm appearing for the department, my lord.
Yes. What were you submitting?
My lord, they are illegally appointed teacher, my lord.
Have you filed your return?
My lord,
Have you filed your return?
no.
So let me issue notice. In the meantime, you file your affidavit.
my prayer is that there's a direction on the court. Today is for the consideration of it because of the fact that if they are delayed in giving pension, they will be required
Mr.
to give.
Borwa, their case is that you have been illegally appointed. Now, if your appointment is illegal, perhaps. Anyway, let them file their return.
No, that is also the judgment is there.
Mr. Borwa, let them file their return.
Then
I'm giving a short time.
GPF cannot be withheld. GPF amount cannot be withheld. It is my money.
Very well, let them file their return first. Yes. Heard Mr. P.P. Borwa, Learned Counsel for the petitioner. Stop. Also heard MS
And Fukan.
for respondent
1 to 5.
1 to 5. Anybody else? For respondent, so and so. By way of this petition under Article 226 of the Constitution of India, Mr. Gogoi, you're also appearing, and B. Gogoi. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking release of the pension and other retirement benefits due to the petitioner who retired from service on attaining the age of superannuation as an assistant teacher of Bhalukaguri LP School of Lakhimpur District, Assam. Correct?
Yes.
Stop. Issue notice, returnable 2 weeks. No, returnable at a date at that date. Give a date after 2 weeks. Returnable on 11th 6 2024. Stop. MS, you accept notice on behalf of
1 to 5.
MS so and so accepts notice on behalf of respondent number 1 to 5. Yes, respondent 6, B. Gogoi for R6, and 7 and 8, so and so for 7 and 8. Stop. Considering the nature of relief sought for in this writ petition, needless to clarify that the concerned respondent shall file their return positively by the returnable date, failing which the petition shall be considered on its own merit. List accordingly.
Item 7 is the same, only the date of retirement is different.
All right. Date of retirement to. What is the date, Mr. Borwa?
Earlier was the.
No, in item 7.
Item 7 is 27/12/2015.
All right. 27/12/2015.
Item number 8.
In charge principal, Mr.
My lord,
Ponto.
your lordship kindly see. Yes, my lord. My lord, your lordship kindly straightway goes to page 24, my lord.
Page
Page
24.
24. Page 24.
Yes.
My name in serial number 2. So I am Mujidul Islam Sodhuri.
Yes.
So my lord, against me, your lordship kindly say, although I am senior, I was appointed in the year
What
1990.
right do you have for in charge?
Yes, I am the senior. Normally, my lord, senior person has been
That
allotted.
is normally.
Normally. So here in
I
this
think there is a decision of Justice Chalmeshwar in this.
there are several decisions, but
Of this
my
court also.
probably my ground of rejection, the person who is more than 15 years junior to me, he has been, my lord, given a charge of the
Who has
principal.
been given charge?
Given serial number 4, my lord.
Serial number 4. Where
4.
do we get it that he's 15 years junior to you?
Then he was appointed in the year, my lord, 2000.
1 second. At serial number 2, the date of appointment is 23/8/95.
My lord.
Okay. And serial number 4.
2014. Serial number 4, 2014. No, issue is involved which, my lord, here in this case, my lord. So your lordship kindly see against my name, that is serial number 2, my name, that there is no NOC for B.Ed and BSc. So if I am not taking permission for B.Ed or BSc course, that, my lord, did not, my lord, make my degree invalid. So that is the point, my lord, involved in this case, and that has been already been decided by this honorable court in 2 judgments. One is by Honorable Justice Bujor Guru, one is by Honorable Justice P.K. Nair, my lord. That is right place, my lord. But since there is a private respondent, you lordship kindly issue notice, my lord, at this stage.
Heard Mr. T.J. Mountain, learned senior counsel, assisted by
M. Islam.
Mr. M. Islam, learned counsel for the petition. Stop. Also heard M.S.
P. Das.
P. Das, learned
Standing counsel.
Learned standing counsel,
Secondary education.
secondary education.
1, 2, and 3.
For respondent number 1, 2, and 3. Anybody else?
Yes, there is a private respondent
Four is
who
private. All
has
right.
given in charge principal.
All right. By filing this petition under Article 226 of the Constitution of India, the petitioner is challenging the appointment of respondent number 4
As a in charge
as
academic
academic in charge
Of the
of
school.
the petitioner's school with the order dated 31/2024.
My lord.
Issue notice returnable 4 weeks. MS so-and-so accepts notice on behalf of respondent number 1, 2 and 3. Extra copies within the course of the day. Registered post AD in respect of respondent number 4.
4, my lord.
List after 4 weeks on a date to be fixed by the registry.
Diploma.
DPO. Wrongly listed. Division.
It is submitted at the bar that this matter has been wrongly listed. Stop. Let registry verify and do the needful.
DPO.
Yes, regularization.
Yes, Lordship.
Your appointment is legal.
Yes, Lordship.
Where is the appointment order?
Connection number 6, Lordship.
Page.
Page number 25. And I have joined in on my joining report is on annexion number 7, 8 November 2010. Page number 26.
All right, issuing notice at this stage. You are
Yunanda.
heard MS Nanda, learned counsel for the petitioner. Stop. Also heard Mr. Who's appearing? MS so and so, learned standing counsel.
Secondary education.
Respondent number 3. You don't have a copy of the petition?
One and 3, Your Lordship. 1, 3 and 4.
1, 3 and 4. Stop. Who will be appearing for 2 state level scrutiny committee? Yes?
SMC. SMC.
Yes, Mr. Kaushik, you are appearing?
Provincial ID.
Who is appearing?
Provincial ID.
Mr. B. Ajay, 1, 2, 3, 4 then, correct? And what about district scrutiny committee? Mr. B. Deori for respondent number 5. And 6 and 7 will be registered post, I think, right? Stop. By way of this writ petition, under Article 226 of the Constitution of India, the petitioner is seeking regularization of the service of the petitioner as assistant teacher of Motirchar High Secondary School, Dhubri. Stop. Issue notice, returnable 4 weeks. MS so-and-so accepts notice on behalf of respondent number 1, 2, 3, 4. Stop. Mr. Deori accepts notice on behalf of respondent number 5. Extra copies within the course of the day. Registered post AD in respect of R6 and 7. Steps within a period of 2 days.
Name of GA Assam.
List after 4 weeks on a date to be fixed by the registry. Let registry reflect the name of GA Assam in the cause list.
Very clear, Lordship.
Yes.
So by this petition, the petitioner Lordship asserting the legality of the B.Ed degree obtained by the respondent number 6 on the ground that the B.Ed degree is obtained through distance mode, which is not permitted.
Sorry?
The B.Ed degree, the respondent number 6 obtained his B.Ed degree through distance education mode, Lordship. That is not permissible, Lordship, as per the rules. Number 1. Second ground is that if he has also not taken prior approval from the concerned authority, Lordship.
So there has been some violation.
Yes, Lordship. And he also parallelly running a non-government institution. To that effect, Lordship, I have enclosed a particular document that Lordship will kindly see. Page 35, Annex 9. He is serving as a principal of that Christian Academy School, Lordship. So, comprehending, Lordship, all these demands, Lordship, we have already approached the concerned authority and filed representation, Lordship.
Where are your representations?
That representation, Lordship, will find at Annexure 5. This is a page 26. This is the relevant type copy. This is from the Guardian Forum and Annexure 6 from the member secretary of the school.
Who's appearing on the other side?
Secondary education.
Alright, I'm issuing notice. Heard Mr. So-and-so, learned counsel for the petitioner. Stop. Also heard Mr. B. Kaushik. Learned, you are appearing as standing counsel.
Standing counsel.
Learned standing counsel for respondent numbers
1, 2, 3 and 4.
1.
I'm sorry, 1, 2, 4.
1,
3,
2 and 4. 3, Mr. Deori?
Yes, yes.
Mr. Deori for respondent number 3. By filing this petition under 226 of under Article 226 of the Constitution of India, the petitioner is challenging the BEd and MSc degrees of the respondent number 6.
Yes, Lord.
Stop. Issue notice, returnable 4 weeks. So and so accepts for Asana list. You have to extra copies within the course of the day, and respondent number 5 registered AD within a period of 2 days. List after 4 weeks on a date to be.
So pendency may not be barred to dispose of the representation because this was filed in 2023.
Pendency can never be a
my grievance is that to cause an inquiry to the allegations leveled by the...
they are always at liberty to dispose
because
of
it was...
Why you need that observation?
No, it was filed on February 2023.
Needless to clarify that pendency of the writ petition shall not be a bar for the respondent to dispose of the representation dated
17/2/2023.
17/2/2023 filed by the petitioner in the meanwhile.
Filed by the Guardian Forum. That was filed by the Guardian Forum.
Next.
Obliged.
Salaries. Why salaries have not been released?
He is paying for lordship leave encashment and lordship some period of suspension notice may go at this stage.
Short date to find out leave encashment, whatever these are monetary benefits. They should be released. These matters should not be kept pending.
This one is there also in page 105.
Page?
Page 105.
Yes. What do you want to show from here?
It says that lordship there is a serious anomalies occurred due to the grant of pay during the suspension period. Lordship.
All right, you take notice.
Before that, I may be allowed to notice it go, my lord. While I was being stated, my lord, one
observation was made by the director, my lord, saying that he followed the Assam Services Discipline and Appeal Rules, Rule 8. And there was a mention about the synopsis of synopsis number 18. We have not found anything in the...
All right, let them first file the return. Heard Mr.
M.K. Mishra.
M.K. Mishra, learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned. You are appearing as?
Standing Counsel, Higher Education.
Learned Standing Counsel, Higher Education.
For
respondent number?
1 and 2.
1 and 2.
I'm for 5 figures.
C. Borwa for 5. 3 and 4 by registered? By way of this petition under Article 226 of the Constitution of India, the writ petitioner is seeking direction for payment of full and complete salaries during the period of suspension with effect from 28/12/2018 till 30/6/2020, and also the leave encashment benefit amounts which has not been granted by the Director of Higher Education, Assam. Vide its order dated 30/6/2020. Stop. Let notice be issued returnable 4 ways. So and so accepts notice. Extra copies within the course of the day. Registered post AD in respect of 3 and 4. List after such and such date on a date to be fixed by the registry. Yes, next.
Item number 30.
Yes, Ms. Varma.
My lord, I have some mistake in the
salary, huh?
I have some mistake in the petition, my lord.
You want to correct it?
Yes, I want to correct it.
All right, you correct it. I'm posting it on Monday. It can be corrected by hand.
No, my lord. Page I have to change 2 pages, my lord. One annexer B3 and annexer C. Vernacular is correct. Only typing.
Yes, amendment like one. Anyway, then you check with the registry. Maybe you might have to come up with an application.
Application, yes.
I'm posting it after a week. As prayed for by MSP P. Borman Learned Counsel for the petitioner, list this matter after a week on a date to be fixed by the registry. Yes.
My lord, that observation will be given that there is a mistake in the petition.
That you check.
Much of it. Item number 14.
Lordship, I am paying for password number for time being, Lordship. My series is on the way.
Next. Death benefits.
My lord, at this stage notice may be issued, my lord. I am seeking family pension as per old pension scheme, my lord. As because, my lord, husband of the petitioner, my lord, selected in the year 1996.
You are also seeking monthly pension.
Monthly pension.
Family pension.
Family pension. Heard Mr.
K.R. Padgiri.
K.R. Padgiri, Learned Counsel for the petitioner. Also heard Mr. P. Nayak.
I am appearing for 6 and 7, Lord.
Learned as Standing Counsel.
Yes, Lord.
Learned Standing Counsel.
BTC.
BTC for respondent number
6 and 7.
6 and 7. And yes.
I am appealing for 1 4.
1 and MS S. Sutia, Learned Counsel as Standing Counsel. Learned Standing Counsel. Elementary Education for respondent number 1 and 4. Yes, Mr. Gogoi. Mr. B. Gogoi for 3. Who is appearing for 2? Mr. Deori? Mr. Deori for 2. And 5 also?
Yes, Your Lord.
Yes, 2 and 5. By way of this petition under Article 226 of the Constitution of India, the writ petitioner is seeking direction from the respondent authorities to finalize and release the death benefits and monthly family pension services pension rules 1969. Stop. Issue notice returnable 4 weeks. So and so accepts notice on behalf of the respondents. Extra copies within the course of the day. List after 4 weeks on a date to be fixed by the registry.
Item number 6.
So I am appearing for 5, 6, 7, 8 and 9.
8 and 9.
It becomes very difficult when you all keep changing the numbers.
I'm based on
Unnecessary time of the court gets wasted. You should be sure of which respondents you all are representing. Yes, Mr. Nayak? You are appearing for?
7 and 8. 5, 6, 7, 8 and 9.
6, 7,
8 and 9.
8 and 9.
All right.
And the rest remain same.
Same. Item number 16. It is a Lordship. Lordship, this has been filed for provincialization of the school allowance.
Yes.
The petitioners are the teaching and non-teaching staff of the school. The school has been operating since 98. In 2005, we got the government approval.
2005?
Yes. Post which we went for the provincialization of the school. At that time, the section that 2535 was there, which says that minimum 25 students criteria had to be followed throughout. Accordingly, we got the cumulative data of 2015, 16 and 17, which stated that more than 25 students were available in the school at that period of time. Accordingly, thereafter, inquiry was done, and which has some discrepancy with our number of students, and thereafter we came before this honorable court by filing a writ petition for provision of the school. At that moment, my writ petition was disposed.
Alright, at this stage only notice
Direction.
can go.
Notice.
Heard Mr. J. Singh,
Singh.
Learned Counsel for the petitioner. Stop. Also heard Mr.
U. Sharma
U.
for Secondary
Sharma
Education Department.
for
Secondary Education Department.
respondent numbers.
The respondent number 1, 2, 3.
1, 2, 3,
4 and 5. And 4 no. No 5.
1, 2, 3 and 5?
Yes, and 4 is Assam High Secondary
Yes.
Education Council.
Who is appearing for 4?
Assam High Secondary Education Council.
Assam Higher Secondary Education Council.
Higher Secondary. Then DK Roy.
Why so much confusion?
DK Roy generally appears.
Shall I record his name? Can you inform him? Or otherwise?
My lord, actually, Assam Higher Secondary Education Council's name has not been reflected in the course list here, my lord.
Mr. Singh, you furnish a copy. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is seeking direction from the respondent authorities to for provincialization of their services and to grant them the benefit of provincialization with effect from the date when the service of teachers and non-teaching staff of other venture school were provincialized in pursuance of the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions, Act 2017, and the Assam Education Provincialization of Services of Non-Teaching Staff of the Venture Educational Institutions Act 2018. Stop. Issue notice returnable 4 weeks. So and so accepts notice on behalf of the respondent numbers. It will be the extra copies in the course of the day. Let extra copy also be furnished to the office of the Assam
Higher Secondary Education Council.
To Mr. B.K. Roy.
No, I am U. Sharma.
No, Assam High Secondary.
Assam High Secondary Education Council.
D.K.
Roy. D.K. Roy.
D for Delhi.
Yes.
To Mr. D.K. Roy, Learned Training Council for Assam Higher Secondary Education Council. Stop. Extra copies in the course of the day, Corridor and episode. List on so-and-so, list after so-and-so date on a date to be fixed by the registry. Let registry reflect the name of Standing Council, Assam Higher Secondary Education Council in the cause list.
Okay.
See, the petitioner is the retired employee of Guwahati University.
Taken, let the petitioner speak. Why you all are in such a hurry? The protocol demands that the petitioner side will first say, if you have any issues, we will accommodate. Yes.
See, the petitioner is the wife of retired employee of the Assam Guwahati University. Till his demise, he was getting the pension, but after demise, suddenly it has been stopped.
So that is what is the challenge.
Yes, Lord.
Very well, let them file their return then.
Yes, Lord, because it is necessary.
Correct. You are appearing for?
Standing Council of Guwahati University.
Heard Mr. Casey, item number 17. Heard Mr. S.E. Kal, Learned Counsel for the petitioner. Stop. Also heard Mr. P.J. Fukan. Yes, you are appearing for?
For the Guwahati University.
For respondent number 1, 2, 3.
1, 2, 3, 4, 5.
For all.
For all.
For the respondents. Stop. The by filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking direction from the respondent authorities to pay for payment of family pension. Stop. Which is alleged to have been due since 31/2022.
2020. Yes.
Issue notice, returnable 4 weeks. Mr. So-and-so accepts notice on behalf of all the respondents. Extra copies within the course of the day. List after so-and-so weeks on a date to be fixed by the registry.
That respondent number 5 is the Secretary Guwahati University Pensioner Association.
You will not appear. So
I'll take 5 steps only.
R5.
Respondent number 5.
Respondent number 5 by registered post AD. All right.
Most of it.
Excess drawn amount pension.
Yes, my lord. That was the allegation, but my lord, I discharged my function as EDA since the day of my.
Sorry, discharge.
The function as EDA all left till the day of my retirement on 19/12/2019. Now, my lord, at the basis of a letter issued by Director, the Lordship may kindly see page 61.
So now they are trying to
draw the excess amount.
Recover the excess amount.
Yes.
Which is to 30,000. What is the amount?
Amount is not mentioned. It is only that is Annexure 7, page 54. May you kindly be seen.
Page 54.
Yes.
Yes.
So here is only mentioning that he has drawn some excess amount. Kindly see the last portion. As UDA assistant, then his designation at the time of retirement is to be UDA as a grade and grade pay for ROP 17 is to be rupees 8,000. But his designation has been.
What are you seeking today? I'm issuing notice. Anything else?
My lord, may kindly issue notice, and till then this recovery may not be done, and provisional pension may be made till finalization of the pension matter.
This court may say no coercive action till the next date.
Yes.
All right.
But the provisional pension which was paid 15,000, that may be continued. They were paying 15,000 on the basis of Annexure 10. Lordship may kindly say Annexure 10, that is page.
All right. Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner. Stop. Also heard Mr.
U. Sharma.
U. Sharma for respondent number?
Respondent number 1, 2 and 4 minus.
1, 2 and 4. Yes.
Is the
respondent number 3. And who's for the college, for the school? Anybody?
No.
That will go by registered post. Okay. The challenge made in this petition under Article 226 of the Constitution of India is to the letter dated 7/9/2021 issued by the respondent number 3, whereby for recovering the excess drawn amount drawn up by the petitioner since the day of reverting him to the post of LDA from UDA on 25/7/2008 till the date of retirement of the petitioner on 31/12/2019. And to pay the petitioner's due pension on the basis of his basic pay at the time of his retirement. Stop. Issue notice, returnable 4 weeks. So and so accepts notice for so and so. Extra copies within the course of the day. Registered post in respect of R5. Upon hearing the parties on the interim, comma, it is provided that the respondent number 2 and 3 shall continue paying the provisional pension to the petitioner, which has been paid till April 2024 at the rate of rupees 15,145 per month till finalization of his pension. Stop.
I love it. But one word is found missing. May I correct it? I love it.
Yes, Your Lordship.
Compassionate appointment.
Yes, my lord. Here there is a typographical mistake at page 5, my lord. Instead of secondary education, it has been typed as elementary education, my lord.
You make the correction by hand.
Yes,
against compassionate appointment against who died?
Father, my lord.
When?
He was missing since 25/2014, my lord, and he was declared dead, my lord, by the authority. At Annexure A, page 15. That is 2/6/2022.
2/6/22.
22.
When did you make your application?
Application, my lord. 22, my lord. On 18/7/22, my lord.
All right. Yes. Why is it not? Why is the application is still pending? No, you have it immediately because it's a compassionate appointment. 22 only the application was filed. We are in 24 now. The entire object of granting compassionate appointment in the meantime has already become frustrated. What is this? Heard so and so and Rupak somewhere number. The grievance canvassed in this writ petition filed under Article 2 to 6 of the Constitution of India is non-finalization of the case of the petitioner in respect of appointment on compassionate ground. Stop. Let notice be issued, returnable 2 weeks. So and so accepts notice. Yes, please give your appearance slip on behalf. All respondents are duly represented, right? Yes. List after 2 weeks and a date to be fixed by the registrar. Needless to clarify that the issue involved in this writ petition is non-appointment of the petitioner on compassionate appointment despite filing representation on 22
on
18/7/22 immediately after the death of
her father,
of his father, comma, the respondent shall positively file their return by the returnable date.
May it please the Lord.
Yes.
Let these petitioners, their services were regularized as the assistant professors. In the
regularized as
assistant professors. Assistant professor. These colleges were private colleges. They were working cancer institutions. In 2013, these services of different colleges were provincialized. It's just non-teaching. But that time, so for the petitioners' colleges were concerned, there were no qualified principal. Therefore, the post of principal could not be regularized. No one was there. Bearing the post of principal, the other posts
were regularized.
And thereafter, to run the college, the governing body as well as the government, the directorate, appointed these petitioners. They are holding the substantive post of assistant professors. They were asked not appointed, they were asked to discharge the function of the principal.
So the petitioners were discharging
The duties of
principal.
Since then.
By way of this petition, what are you seeking, Mr.
Now
Mahanta?
we want
The
that the
benefits?
authority want to advertise those posts and get them. Some of them meanwhile has attained the required
So you
qualifications.
cannot compete for the post.
Yes. So authority should consider our case for absorption against those posts. If necessary, we have said
You filed a representation.
representation was filed,
Where
but
is
that
it?
has not been annexed here.
Why?
This was filed. We have made a statement. Statement is there, but copy could not be annexed because it was not retained. It was directly sent to the Honorable Minister of the Department. It was there. Therefore, now the grievance.
All right, Mr. Mahanta, then only notice can go. And I shall observe that in the meantime there is no bar for absorbing or regularizing.
Yes. Let the notice go to them.
Mr. Gogo, I am not issuing any stay.
Regarding that observation part also, we have to go by the rules and regulations.
I am saying pendency of this writ petition shall not be a bar. You have a problem in that?
I have no problem. Otherwise, Lordship, the rules says that we should get direct recruitment, Lordship, by advertisement. There is no scope for adjustment.
Which is that rule?
2000, after the Lordship,
Show me the rule. So that rule is not
as per 2011, just I point out, Lordship, 2011 Act, Lordship, after provincializations, they are come under the 2010 rules, Lordship.
So their services have already been provisionalized
Lordship, already been provincialized, Lordship,
by the
under
2011 Act.
2011 Act, and after that, Lordship, they are come under the 2010 rules, Lordship. It's in 496, Lordship.
496.
493, my Lord, may kindly peruse, Lordship. 497, Lordship, method of recruitment, rule 5, Lordship.
Yes.
Appointment to the post of principal shall be by the direct selection, but the governing body shall constitute a selection committee, which shall select a person on the basis of the interview from amongst the eligible candidates who applied in response to the open advertisement in newspaper also.
Alright.
This is the procedure, Lordship. We have to follow the procedure, Lordship. Even next page also, Lordship, direct recruitment, Lordship, page 7,
Yes.
rule 7, Lordship.
Yes. Alright. Heard Mr. Heard Mr. K.K. Mohanta, Learned Senior Counsel, assisted by
S. Hawk.
Mr. S. Hawk, Learned Counsel for the petitioners. It will like this. Page. Stop. Google page to like. Also heard Mr. K. Gogoi, Learned
Standing Counsel,
Higher Education.
I am for Lordship 1 and 2, Lordship.
You are for respondent numbers? 1
and 2, Lordship.
Anybody else?
UGC is there also, whether their name is shown or not.
1 and 2.
1 and 2, I am 1 and 2.
1 and?
1 and 2, Lordship.
2. Alright. 1 and 2, stop.
Respondent number 3, UGC is there also.
By way of this writ petition under Article 2 to 6 of the Constitution of India, the writ petitioner is seeking inter alia direction to the respondent authorities to appoint the petitioner numbers 1, 2, 3, 6, 9, 10, 11, 13 and 16 by way of regularization stroke absorption as principal of their respective college and appoint the petitioner numbers 4, 5, 7, 8, 12, 14, 15 and 17 by way of regularization stroke absorption as principal of their respective colleges by granting relaxation of the qualification and or granting 5 years time to acquire the PhD degree. Stop. Issue notice returnable 4 weeks. Mr. K. Gogoi, Learned Standing Counsel, Higher Education, accepts notice on behalf of respondent number 1 and 3. 1 and 2. Extra copies within the course of the day. Registered post AD in respect of respondent number 3, 4, 5, 6, 7, 8, 9, to respond from 3 to
20.
20.
But see, in respect of number 3 Lordship, there is a standing council of UGC there.
But he is not there.
Probably Lordship, their name is not shown in the
Anyway, let notice go.
Sir, we serve a copy to the standing council. We serve a copy to the standing.
All right, to me, 4
in respect of 3.
4 to 20 registered post AD. In respect of respondent number 3, it is submitted at the bar that there is a standing council for the University Grant Commission. Semicolon. Let copy of the petition be served upon the standing council.
And regarding other,
along with extra copy within the course of the day.
Regarding other respondents, my lord, there are college governing bodies. By Dusty, they will be served.
As well as Dusty.
Yes.
I'm not saying anything about the interim right now. Otherwise, I'm going to reject it. So I better issue notice and keep it as
on the interim also. On the interim pair.
Yes, I'm not doing anything today.
On the interim pair also, notice.
Notice on interim as well.
Yes.
List after so and so weeks on a date to be fixed by the registry.
Well, so for private respondents, so for service on private respondents, only by Dusty.
No, I have given both. So in case you do it by Dusty, you file your affidavit of service.
They have to, well, otherwise, Dusty may insist upon that both.
You do it, and then this court will shall see.
Will submit Dusty, they will file it.
Yes.
Otherwise, it is very voluminous.
No, that's all right. You do it. If they are, we do not know whether they will accept, they will not accept. So
that is why I wanted that clarification.
We have registered Lordship. We have registered Lordship.
So therefore, I have given both options. So let them do it and file their affidavit of service. Yes, next matter.
All right.
May I please give you?
Yes, Mr. Borra.
My lord, here.
1 second, Mr. Borra.
My lord. So, my lord, there is a college named Style as Bajali Teachers Training College. That is B.Ed College. And it is affiliated to Guwahati University. Accordingly, my lord, whatever rules, regulations, criteria is there, it is to be followed by this particular institution also. Here, particularly before Lordship today, in composition of governing body, that is also prescribed what manner it is to be composed or constituted. That is will already addition. And what manner it is there. Another aspect also is there. Out there, one provision is there, 4 members are to be nominated from the Guwahati University as a representative Guwahati University. Names should be forwarded by the concerned college. There is a criteria for that. There are no persons other than forwarding by college.
That has not been done.
Not done. There is here the 2 persons, 2 representatives were appointed. Thereafter, we have filed 3 representations by representations by one by one we have filed to university by that time.
So your basic prayer is to nominate the persons recommended by the governing body of Bajali.
Bajali College. That is my lord. That is my lord.
That is what you are seeking.
That is correct. This is outside. It's someone whose names I cannot say outsider. Their names were not forwarded, but it is considered. Notice may go, my lord, and in him.
Notice may go, my lord. We don't have any of that. No, regarding the ordinance, my lord.
Heard Mr. C. Borwal, Learned Counsel for the petitioner. Stop. Also heard Mr. P.J. Fukan, Learned.
Standing Council,
Guwahati University.
For respondent 1, 2, and 3.
Within bracket, respondent number 1,
2, and 3.
1, 2, and 3.
4 and 5 private respondent.
1, 2, and 3.
3.
And who else is appearing? 4 and 5, I think, registered post.
Yeah, registered post.
Okay. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction from the respondents.
University. Guwahati University. Registered.
Inter alia to nominate the persons recommended by the governing body of Bajali TT College as university representatives for the new governing body of Bajali TT College.
My lord.
Stop. Issue notice, returnable 4 weeks. Mr. P.J. Fukan, Learned Standing Council, Guwahati University, accepts notice on behalf of respondent number
1, 2, and 3.
1, 2, and 3. Stop. Extra copies within the course of the day. Registered post AD in respect of respondent number 4 and 5 within a period of 2 days. List after 4 weeks and a date to be fixed by the registrar.
My lord, regarding interim, it is to be little protection is required. No, here what happened, my lord? In that case,
prayer on the next date.
No. That's then in regards I have to submit it to further. What happened? This case already been earlier when the outgoing president, he is also member of this, and he filed a writ petition before this honorable court. This was admitted and interim order was issued. But there on the last 2 days back, this thing again listed. That court has our discussion has come because there may be because affected person is not there. Thereby, it may ultimately this case cannot be in proper form, proper manner. It will be. It is allowing me to affected person to file this case. Accordingly, I am filing. This interim period, that earlier case was there. That is why it was continuing to that. And otherwise, my lord,
on the next date,
then only one line may have reported. My representation is there. Pendency may not be bar to consider. My representation.
That pendency of this writ petition shall not be a bar for the respondents to consider the representation filed by the petitioner in the
petition by the college authorities, because that time college authorities is the right person. Also, that is also can be.
You said you have filed 3 representations.
I have not filed. College has filed because secretary is the authority. President is the authority.
Authorities relating to the issue involved in this writ petition.
Most of.
All right.
Next.
Hello.
May I please, Your Lordship?
Yes.
I filed for the vacation of the
Vacating
interim
stay.
order, Lordship. The interim order, Lordship, is the page 19, Lordship. Where the relevant page is 20.
You want to file an affidavit?
I filed an affidavit,
but it is not on record. It's not on record.
Huh? It says that today filed.
No, not today.
No.
Not today, my lord.
But we have also not
filed.
My lord, on 1
Your name?
S. Gorpatra
MSS Gorpatra Goyal Learned Council for the respondent.
I'm not for the respondent, my lord. I'm for the petitioner. He's for respondent.
In the interlocutory application, you are a respondent, correct?
My lord.
Correct
Lord,
or not?
yes,
My
Lord.
lord.
Yes,
Then,
one.
for the writ petitioner stroke respondent, number 1 submits that an affidavit of objection has been filed in the interlocutory application on.
My lord, my lord, I have filed a reply, my lord. He has filed the interlocutory application. On 1/4/2024, my lord.
You have filed an objection in the interlocutory application, or you have filed a reply to the affidavit?
I have filed a.
What have you filed?
I have filed a reply to the IA, my lord.
So that is an objection.
Objection, my lord.
Otherwise, you see, you are unnecessarily creating confusion.
My lord.
Use the name which one is familiar with. Kibuli Lekhila, Aparna. An affidavit in opposition, Lekha. An affidavit in opposition has been filed in the interlocutory application on
1/4/2024.
1/4/2024. Semicolon. However, the same is not on record. Let registry verify and place the same on record. List on Monday.
Monday.
God bless you.
Yes, Mr. Sharma?
The other side wants time for a week to file.
You want to file an objection?
We'll file it.
In the interlocutory application?
Lord.
Your name?
D. Mohanta.
As prayed for by Mr. D. Mohanta, Learned Counsel for the petitioner stroke respondent.
That's it. Private.
Petitioner stroke
Petitioner.
respondent. Number?
Number 1. Sole respondent 1.
Petitioner stroke respondent. list this, which is not opposed by Mr. R.P. Sharma, learned senior counsel, assisted by
M. Bora.
MS M. Bora for the learned counsel appearing for the applicants, comma, list this matter after how much time?
After 1 week.
After 1 week on a date to be fixed by the registry to enable the petitioner stroke respondent to file their objection in the matter.
Item
number 22.
Impleadment.
May I plead, Lordship?
Yes, who you want to implead?
Lordship, Sri Narayan Kaur, Secretary to the Board of Assam Secondary Education
He
Department.
is presently holding the post.
Yes, yes, Lordship.
In item 22, Aparna. Heard Mr. P.K. Das, learned counsel for the petitioner stop. Also heard Mr.
I am for the earlier director of SMT Sisti, Lordship.
You are for
Yes.
Mr. SMT Chisti, learned counsel appearing on behalf of contender number?
Lordship, P. Jidung, under 3, Lordship.
Contender number 3.
3, Lordship.
The rest of the respondents are not represented.
Some of them are already retired, Lordship.
Stop. This is an application for impleading Sri Narayan Kanwar as party respondent stroke contender number 7 in the contempt petition civil number 538 of 2020. Stop. Mr. Das, learned counsel for the petitioner for the applicant submits that who died?
Did not died.
Not Lordship. One retired.
That the proposed that the respondent number 7
earlier it was 5
sought to be arrayed is now holding the post of
Secretary
Department
of School Education,
Department of School Education, Assam.
Yes, sir.
And accordingly his presence is essential and necessary for effective adjudication of the contempt petition.
Yes.
Stop. Prayer allowed. Let it is direct. Prayer allowed to next paradigm. As such, Sri Narayan Kanwar, Secretary to the Government of Assam, Education within bracket Secondary Department, is impleaded as respondent stroke contender number 7 in contempt case C number 538 of 2020. Stop. Let amended cost title be submitted before the registrar for doing the needful. Disposed of.
For admission, item number 26.
This matter is pending since 2019, my lord.
None appears for the petitioner when the matter is called. List after 2 weeks on a date
My
to be
lord,
fixed by the registry.
My lord, I have some urgency. Kindly fix on Monday, my lord. In this
List
case,
next week on a date to be fixed by the registry. Next. Just 1 second. Considering there was no representation on behalf of the petitioner when the matter is called, list this matter next week at the date, did you? Wednesday. On so and so date with remark within quotes for dismissal.
Item number 24.
May I please, your lordship?
Yes.
Matter lordship, despite the repeated order of this honorable court, lordship, no affidavit has been filed.
Yes, Mr. Chaudhary.
Lordship, the affidavit is in the process of filing today itself, lordship. Within half an hour, you will receive it.
Mr. B. Chaudhary, Learned Standing Counsel, DPC, submits that the affidavit in opposition shall be filed within the course of the day. Stop. In view of the aforesaid endorsement, list this matter.
2 weeks, lord.
Give a date on so and so.
Deeply obliged.
Item number 25 and 26.
lordship, I would ask upon your lordship to take up item 26 first, lord.
26 are filed, Tagodya. Have you filed your reply?
No, lordship, but then lordship, in this matter, all the other candidates who participated along with the...
Will a rejoinder not be required?
In 26, Lordship, I don't think it will be required, Lordship.
Yes.
Lordship, all the other candidates who participated along with the petitioner, Lordship, they had already retired, as per my instructions, Lordship. And we had challenged an
So
order.
this matter has become infractious.
Not possibly, Lordship, because there is an interim direction, Lordship, not to give the results, Lordship.
Who has retired? The
Other candidates.
Other candidates.
Yes, Lordship.
Is
Lordship,
it
may
correct,
kindly
Mr.
tell us
Chaudhary?
order dated.
I have no instruction, my lord. I appear in item number 25. I am for the respondent
And
number
what
5.
about in 26?
26.
You are appearing?
I am for the respondent number 5.
Has he retired in the meantime?
Not the petitioner, Lordship, but
No, respondent. He's
they
appearing.
are not respondents in this matter.
Who are the respondents? Who's appearing for those respondents?
Lordship, he probably appears for the school selection committee, Lordship. And in terms of order dated 21/6/2019 in this matter, Lordship, it was directed that the results be kept in seal cover, Lordship. The last.
Yes.
Lordship, if that results are declared, Lordship, then probably the issue will be resolved, Lordship.
Yes, who's going to respond to the submission made? Mr. Chaudhary is not concerned with item 26. Yes. No, a submission is made that in term there is an interim order of 21/6/2019 which mandated you to keep the records of selection in the sealed cover. Correct. Now they are saying that since the private respondents have retired in the meantime, so this can be, you can go ahead with it.
Just for the process, my lord, the interview was called for fresh interview, and it is the fresh interview taking of the district. Now, one of the candidates, two of the candidates have already been retired. Now, if the selection process continues as per the earlier, there should not be any hurdle for the petitioner.
In fact, they are saying that.
Lordship, if the fresh, this is with regard to the fresh selection itself, Lordship. And if the results are published, Lordship, then the grievance there would not be any.
Because the earlier that instruction was by the government respondent is that fresh interviews to be called. If those who have retired, they will not be able to participate because their tenure is gone. So whatever is the remaining.
You do one thing then, you get a specific instruction. Because otherwise, I don't think it will be proper. Because otherwise it appears that if you publish the results, the petitioner is satisfied. However, since you are saying that in the meantime they have been retired, therefore a fresh election may be required, so you get that instruction, whatever it is, in view of these development. Mr. Chaudhary,
No,
anything in
Lordship.
your matter?
That would not come in, Lordship, because
Let them obtain the instructions.
because there is a
You
direction
wanted
of this Honorable Court earlier
very
that
well, but now you want a disposal in terms of this. Now they have a right to get their instructions because
Yes,
of
yes.
development.
So far as my
How
case
can you
is-
obstruct that?
No.
Then, yes,
So for
Mr.
my
Chaudhary.
case is concerned, I am the only private respondent. So his submission does not
But
affect.
let it, since it's along with this, so
Let it be
in
there.
view of this, that matter also I'll post it
Yes.
on the same date. How much time do you need?
After 2 weeks,
Your name?
my D. Nandi.
Mr. Deena?
Nandi.
Huh?
D. Nandi.
Mr. D. Nandi, Learned Council,
For the respondent number 5.
appearing on behalf of respondent number 5, seeks 2 weeks time to obtain instruction as regards the development that has occurred in the meantime. Prayer allowed. List this matter. You want a date?
Yes, sir.
After 2 weeks, date. 12th.
All right.
So, and in the second matter, list along with Court 25 to 26 on the body. In item number? I'm not recording anybody's presence. You are all there already on record. In every order, if we start recording presence, it becomes very difficult for the stenographers because it takes a lot of time in typing. Effective orders we mentioned.
Item number 27.
It appears from the order, it appears that on the last occasion, I-8/1/2024, none appeared for the petitioner when called. Stop. Further, today when the matter is called, there is no representation on behalf of the petitioner. Stop. Yes, your take their appearance. You give it to the courtmaster, all of you. In view of consecutive non-representation on behalf of the petitioner, the writ petition stands dismissed for non-prosecution. Yes, instructions, Mr. Kaushik.
My lord, I'll pray for some time, my lord, because the DO...
The 22 matter...
True, my lord. My lord, they have filed this case based on the statement that is submitted by the DO. The director has asked the DO to...
Mention?
No, my lord. Area salary.
No, not area salary. Well, I have got everything. Only thing is that since 1998 I was appointed, till 2005 December I was getting the salary. Since 2006 January I was not getting. I prepared a writ petition that was dismissed. In writ appeal I was allowed, and accordingly I have been given all these things. Only hurdle is that, Lord, at the time of payment of area salary and my current salary, although I was appointed in 1998, instead of placing me in the old pension scheme by allotting GPF account, I have been placed under new pension scheme.
All right, let them then file their return.
That is the problem.
Mr. B. Kaushik, Learned Standing Counsel for the Secondary Education Department assures that the necessary return shall be filed
within 3 weeks.
Within 3 weeks from today. Stop. In view of the aforesaid assurance made by Mr. B. Kaushik, list this matter of the 3 weeks on a date to be fixed by the registry. I'm appealing for the account to file something. No,
much.
Yes, Mr. Goswami.
May it please your lordships. Pleadings are complete. A very short matter point is involved. The petitioner before your lordships is praying for 3 principal
Who's
relief.
appearing on the other side?
Education Department.
Yes, Mr. Goswami.
Can I proceed? Would lordship kindly come to the relief that I am seeking, which is at page...
You are appearing? Yes.
Page 11 of the writ petition. 3 principal reliefs.
Yes, please.
The first relief that we are seeking is allowing the petitioner to continue working as a regular assistant teacher until his retirement with all consequential service benefits as per his appointment dated 19/12/89 issued by the respondent number 4. Yes. The second relief that we are seeking is setting aside and quashing order under memo number so-and-so dated 30/1/2021.
What is this order, Mr. Goswami?
This order is at page 53, which order is the order appointing me as a tutor. It is our case that our services have been regularized. The regularization order is on record, so thereafter you cannot demote me and appoint me as a tutor.
You want regularization to which post?
This regularization order is, we have been regularized on 15/6/95, which order, lordship, is at
15/6/95?
Yes, lordship.
To what post?
Assistant teacher.
So after this, now they are again...
Actually, this case is a checkered history. I'll take lordships to the facts of the case.
No, but just to understand you, now from assistant teacher, now they are regularized you to the post of tutor.
Yes, not
reappointed.
Reappointed as tutors. Okay. On the premise that our services was terminated in 2007, which case went up to the Supreme Court. And then the Supreme Court ordered in favor of the employees. I'll place the judgment also in lordship's favor. Now, the third prayer that we are seeking is to
salaries.
Yes, salaries.
This was area salaries?
Yes, from 2007 till 2021.
Yes, where is the 31/21 order?
31/21 order is at page 53, lordships.
Yes.
Annexure 11.
Yes, I have it. Please read.
Order in exercise of powers conferred under the Department of Elementary Education, Assam, via government letter dated so-and-so, dated 4/1/2002, and in pursuance of the government approval communicated by so-and-so, dated 21/1/2021, and dated 27/1/2021, I, subject to satisfactory police verification report and production of physical fitness certificate from concerned Joint Director of Health Services, the following candidate is hereby accommodated as tutor in LP/UP school on purely temporary basis in the fixed salary at rupees 10,800.
What is the stand of the government?
The stand of the government is very simple. They say that these services were illegal. They were appointed against non-sanctioned, non-existent posts. So the government terminated its services vis-a-vis 2007. And since 2007, salaries have not been paid because they were never working and they were against non-existent posts.
Yes.
Now we have taken a policy decision to appoint these people as tutors,
yes,
and to pay them a fixed salary. And the counter affidavit that is on record, they say we have no records. Our records have been seized.
So these are, according to them, this appointment have been illegal.
Illegal and terminated. Now the issue remains, you may say it is terminated,
Yes.
but where at any point of time termination orders issued to them. A case out of this lot went right up to the Supreme Court.
Yes.
And the Supreme Court was very clear that pay salary to that petitioner in that case, and her termination.
Where is the initial appointment?
Yes. My initial appointment order is at page 16. In fact, if Lordship said before my initial appointment, there was a selection process held. If I may first take Lordships to page 14 of the writ petition.
Yes.
If Lordship says this is an order of 16/10/86,
Yes.
and this is addressed to me.
Yes.
On 2/11/86 at 10 a.m., written examination will be held for the post of LP school teachers for Dhemali districts in the below mentioned center. Written examination will be held for the candidates. Those are under mentioned panchayat shown against the name of the center. Candidates are requested to present at the exam with one foolscap paper and pen before 30 minutes of the exam. So
there was a selection.
There was a selection. May not be as, but there was a semblance of selection. It is not a random pick. And there were many candidates who participated. Thereafter, my appointment order comes at page 16.
Mr. Goswami, you are aware of that decision of the Apex Court in 2011,
Yeah.
where it says that if the appointment is without advertisement, here an advertisement was there. It was not there. So if the appointment is without advertisement or for any other reason the appointment is illegal, no relief whatsoever, even salaries will not be granted.
That's the Orissa matter.
Yes.
No, true, but then there has been dilution. There would be orders on the other side also, judgments also on the other side, which I will place, and ultimately it is for the court to take a call. Because ultimately, Lordship, the overarching principle in deciding cases, they've been fairly treated.
Paragraph of the affidavit where they have said it is illegal.
Yes,
And
their
you have
affidavit.
you have filed your reply, Mr.
We have filed a reply. Pleadings are complete.
Where is it in the affidavit?
Their affidavit, if Lordship will come straight to page 55,
Yes, I have 55.
para 5.
Yes.
That the deponent states that as reported by the District Elementary Education DEO Dhemaji by this letter dated so and so, there was no record regarding selection and appointment of the petitioner.
So they say there is no record of appointment or selection.
Absolutely. And then thereafter they go to say, as such, it is also not known as to whether the petitioner applied for the post of assistant teacher in LP school or selected and duly appointed. It is stated that the appointment files of those persons who were appointed during the year 1999 under Dhemaji was seized by one so-and-so, by the Caesar list dated so-and-so.
Yes, who is appearing for government? On what basis you are saying that there was no selection when it appears from this annexure at page 14 that some selection was there, number one. Number two, you are saying there is no record of appointment, and then again you are saying then some records have been seized. You cannot be blowing hot and cold. You have to take one stand. Either there is no selection or there is selection. Prima facie, it also appears that some selection process was started at page 14. Have you replied to this page 14 document?
So that's why the affidavit we have
No, you cannot simply say there is no record. You have to also apply your mind when you are drafting our affidavit, correct? This page 14, where is your averment as regards page 14? Because page 14 indicates on 2/11/86 at 10 a.m. written examination will be held.
My lord, in this regard, I will
No,
take
where is
instruction.
the, huh?
I have to take instruction. my
No,
lord,
what
because
is this piecemeal instruction business, Mr. Counsel? You have filed an affidavit in opposition. Why have you not answered all the allegations and everything at one go? You cannot be going on filing affidavit after affidavit. Yes, Mr. Goswami?
Yes. In fact, if Lordship is in the affidavit, please see para 8 also. It is even more interesting reading. If
See, I am not saying that what you are saying is wrong. You have to take one stand. Either you say there is no selection at all, but you can't say that because some records have been seized, you do not, then you say that you don't know. You try and obtain those records. Yes, Mr. Goswami, paragraph 8.
yes, that the petitioner was subjected to a screening process undertaken by the government in the year 2012. The matter relating to the screening verification process of illegal, irregular excess teachers of Assam has been centrally dealt by the government. After the process was over, the service of the petitioner was accommodated as tutor on 31/2021, issued by this directorate by way of cabinet approval. Accordingly, the petitioner joined as tutor in so-and school. Now, this presupposes a fact. Lordship, it presupposes a fact that this gentleman was working. There was no question of any termination.
No, but on what basis he is now made a tutor when he was working as an assistant teacher?
In fact, if Lordship will see,
Mr. Goswami, this affidavit doesn't seem to be answering
the
everything.
question
It's
that we
inadequate.
raise. And in fact, if Lordship will see, they are on their whole case is that we have been terminated. Now, please see,
There is a termination order.
that is one aspect. That is one aspect. Now, the second aspect which Lordship will also see that when you are appointing a tutor, you don't pick up a random person from the market. Please see the provision under which provision you are appointed as tutor and who are appointed as tutors. Would Lordship kindly see the 2017 Act?
All right. Anyway, we'll not go into all this because it appears that the
In fact, this
affidavit
gentleman,
is not sufficient.
the petitioner, he has already got an order from this court, single judge, saying that pay them their salaries. Then they have to withdraw that.
Salaries have been paid or not?
No, not till today, despite the earlier order, which order is a page.
Salaries against which post? Mr. Goswami, salaries against which
I must be very candid, but he is now being paid the salary of a tutor ever since he's appointed. That to that extent, he is getting the 10,800.
Then at this stage.
Very well, I appreciate. But Lordship will give me a short that
Let
because
them file a detailed affidavit. Yes. Are you appearing?
Lordship will give a short that so that because this man is on the verge of retirement.
Yes. Yes, Mr. Counsel. By looking at my face, nothing is going to happen. You have to say something.
Yes. Although as per government policy, there is against illegal and irregular teacher, cabinet decision has been taken. And
What has been declared?
cabinet decision has
Cabinet
been
decision.
There are the screening committee.
Against what? Against?
Illegal and
Yes, but where are those findings? Where have you found that the appointment of the petitioners are illegal? At one go, you are saying that it appears that there was some selection. Then you are saying there are no records of selection and appointment. Then you are saying records have been seized. Then you are again saying there is a cabinet decision and now you have made them a tutor. Something doesn't seem to be okay in this matter. You have to come up with a concrete stand. If your case is that it's absolutely illegal, no selection, no appointment, certainly this court will not give them any benefits in that situation. This court is making that very clear. But then if they were selected, you can't now from assistant teacher just bring them to tutor merely because the records are not available in your office.
file a additional application.
Heard Mr. M. Goswami, learned counsel for the petitioner. Stop. Also heard Mr.
G.
Pegu, learned
Standing
counsel,
Elementary
Education Department. For all the respondents, stop. Attention of this court has been drawn. This is what document at page 14?
Page 14, Lordship. Page 14 is a call letter.
To the call letter dated 16/10/2086 issued in favor of the petitioner.
Yes, Lordship.
Issued in favor of the petitioner, calling for written examination.
Yes, Lordship.
Calling for written examination. Stop. However, in the affidavit in opposition filed by the respondent number 2 at paragraph 5, the stand of the government is that there was no record regarding selection and appointment of the petitioner. Stop. It further appears that the said stand is further it is stated in the said paragraph that the appointment files of those persons who were appointed during the year 1989 under Dhemaji subdivision were seized by one Shri Jagadish Sharma, Inspector of Police, CMS Special Vigilance Cell, Assam, by the seizure list dated 8/4/1997. Stop. In view of the said paragraph, it is not understood as on what basis the government is leveling the petitioner's appointment to be illegal. Stop. In view, stop. The affidavit thus appears to be not sufficient to decide the issue arising in this writ petition. Stop. Let a detailed affidavit be filed covering all aspects of the issue involved in the writ petition within a period of 2 weeks from today. List on. Yes, Mr. Goswami.
Lordship, if it is so convenient for the court, the week commencing 10th of June. I'm grateful, Lord. Deeply.
Area salaries.
My Lord, Your Lordship may kindly see at page 61 of the additional affidavit of the petitioner.
Before that, my Lord, if the Lordship kindly turns to page 25.
Oh, my Lord, first of all, you will kindly see that. 61 was 61, 61. Very much less salary, some will get 10,000, some will 15,000. The case was filed in 22,000. Since that time till today, no affidavit has been done. Now, many days have been passed for doing that.
Yes, Mr. Kaushik, what is happening? How many more years do you need to file an affidavit in opposition in this matter?
Page 25, Your Lordship will kindly
Yes, we will go to page 25. First, you answer the question. Are you filing return or you're not filing return?
No, but the director, in fact, has asked the DO to give the statement of the area salary in a proper format in the finance department format.
25.
Page 25. These are the formats which were sent by the DO, and therefore it could not be processed well.
All right, then I can dispose of this writ petition. That let the petitioner submit the details in the format.
No, the district elementary education officer. The district elementary education officer has submitted this statement. Page 25, my Lord.
All right. So what is to be done now?
No, this has to be sent in the format that is prescribed by the finance department, and accordingly the director has asked the DO.
Have you informed them?
DO, we have informed the DO.
Where is that letter of yours?
14th of May, my Lord.
Where is that letter?
My Lord, I have received just over WhatsApp, my Lord. The 14th of May.
This court is not
I
concerned
understand.
with your internal communication.
Your Lordship will give us...
The admitted fact is that the area salaries of the petitioner has been withheld since
2016.
2016. Absolutely
Someone
not done.
10,000, 15,000. That was someone only.
You come up with a concrete plan. You sort it out with whatever department you want. If the requisite form has not been submitted by some department, then you ensure that it is done.
We have called for it, my Lord.
When?
14th of May.
14 May 24. What have you been doing since so many years?
The Lordship will give us 2 weeks time, my Lord. I think, my Lord, it's under the active consideration for payment.
Well, finally, these people. Recently, there are some more papers that are already sent to the office. This was his first papers I submitted. This was first area non-real salary. First this much paper have already been sent. Thereafter, they have again sent someone letter. They are simply sending the letters and not with the amount.
From where did you obtain this copy?
That this was already submitted to the office by the petitioner.
Recently. Their author also, they have not marked it.
Office communication, this is not officially marked to you. Where did you get this from? Anyway, Mr. Kaushik, you get all the information. Yes, Mr. Gogo, you've been very silent.
No, my lord, it's their part, my lord. We are waiting for the proposal. It comes, of course, we will consider.
No, but I am just wondering, if everything otherwise is admitted, then why to unnecessarily keep this matter pending?
It can be disposed of.
It can be disposed
with
of.
the time frame, my lord.
Who, the direction has to be given to whom?
The director, my lord.
Respondent?
Respond number 2, my lord.
I can give 3 months time.
Well,
that should be sufficient. So the direction to respondent number 2 to release after in accordance with law.
Well.
Anything to add, Mr. Gogoi?
No,
huh? No, you all are at liberty to tell me if anything is to be there. Because I think that would be just, because it's from 2016 it has not been. Now you will come up with something in your affidavit, then Mr. Gogoi will take time to receive the proposal or not to take that instruction. It will go on for another year. Alright. This is item number 30. Third, Mr.
P.C. Raimedhi.
Mr. P.C.
Raimedhi.
P.C. R. Medhi, Learned Counsel for the petitioner. Stop. Also heard Mr. B. Kaushik.
I am for respondent 1, 2, 3.
Learned Standing Counsel.
Standing
Counsel, Elementary Education Department, and Mr. B. Gogoi, Learned Standing Counsel, Finance Department. Stop. By instituting this petition under Article 226 of the Constitution of India, the petitioner is seeking direction for release of the arrear salaries which are still outstanding. Stop. It appears that the salaries of the subject arrear salaries of the writ petitioners are pending since 2016. Stop. It further appears that from the what is this document at page 25, Mr. Kaushik?
Well, these are the statements sent by the DO and the Treasury.
According to this statement, this claim it appears to be admissible because you see there is a note there.
It seems so.
It appears from the statement details enclosed as Annexure 2 to the writ petition that the arrear salaries claimed by the petitioner are admissible. Stop. Be that as it may.
Hello?
You want to say something?
No.
Are admissible. Stop. Then, however, the same has not yet been released for want of. Don't say has not been released. Stop. Withholding of the legitimate arrear salaries of the petitioner is in violation of is violative of Article 21 of the Constitution of India. Stop. In the interest of justice, this court deems appropriate that this writ petition can be disposed of with the direction to the respondent number
2
to release the subject arrear salaries to the petitioners within in accordance with law within a period of 3 months from the date of receipt of the certified copy of the order. Stop. With the aforesaid observation direction, this writ petition stands disposed of.
Grateful.
Etu ghurai dibo.
May please, my lord.
Yes.
In this case, my lord, I have to file affidavit in reply, my lord.
All right. Your name?
M. Kolita, my lord.
My lord, we have some urgency. Can it be on next week, my lord?
Let him file his reply.
Yes.
My lord.
Your name?
M. Kolita, my lord.
Mr. M. Kolita, learned counsel, appearing on behalf of the petitioner, seeks 2 weeks' time for filing affidavit in reply against the affidavit in opposition filed by
Respondent number 6.
Respondent number 6. Stop. Prayer allowed list.
My lord, kindly be on the next week, my lord. The urgency is that, my lord, since 2019, my lord, I have been, my lord, appointed as a
23
principal.
matter. List after 2 weeks on a date to be fixed by the registry.
Interim order can be.
Interim, if any, shall continue till the next date of listing.
I am deeply obliged.
Yes. You are appearing?
So I am for the petition.
Here I am praying for 4 weeks time to file affidavit.
As prayed for by Mr. B. Kaushik, learned standing counsel, elementary education, which is not opposed by the petitioner, list this matter after 4 weeks to enable the education department to file their return in the matter. It's all right. List after 4 weeks on a date to be fixed by the registry.
May I please, your lord?
Yes.
Matter pertains to the non-payment of arrears salary.
Current salaries.
Lordship, I pray for some time for 5 years.
Since when your salary has been withheld?
From the date of joining and but petition.
From the date of joining?
Yes, my lord. But this is the third time litigation by the petitioner. And the first time after filing the first petition.
Anyway, let them come with. Yes, Mr. Chaudhary, how much time do you need?
Lordship, 3 weeks.
3 weeks salary matter, Mr. Chaudhary. Livelihood is at stake.
Because Lordship, here some of the school mothers, there is an association. They have approached the honorable court, and there was a contempt. Some
As
payment has
by
been made.
Mr. B. Chaudhary, Learned
BTC.
Learned Standing Council (BTC), which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry to enable the BTC to file their return in the matter.
In this case, my lord, after notice, my lord, first time matter is come up. So I need some time.
All right, Mr. As prayed for by Mr. B. Talukdar Leonard.
Standing Council Elementary.
Standing Council Elementary Department, Education Department, list this, which is not opposed by the other side. List this matter after 3 weeks on a date.
2 weeks, and any date may be given.
You are obstructing the administration of justice, Miss Counsel. If you want to say something, say it after the dictation is over.
Okay.
List this matter after 3 weeks on a date to be fixed by the registry to enable the Department of Education to file their return in the matter. List after 3 weeks on a date to be fixed by the registry.
Okay.
It's a 24 matter. Let them have 3 weeks. Otherwise, unnecessarily it will be listed.
Okay.
Supplementary list item number 57.
May I pray your lordship? So matter was heard at length the other day. Lordship had a look at the order dated 17/5. 17/5, order dated 17/5 last week. So item 57 supplementary.
This is part third?
No, not part third, but it was likely to.
We have pointed out, my lord. So far as the issue involved in the present case is concerned, well, the notification, my lord, of which the petitioner is claiming the benefit is already under challenge before the division bench. Exactly on the same point.
So then this matter
We'll have to
will
wait.
have
In
to
fact,
wait.
similar matter, yes.
Similar issue is pending before the division
Yes,
bench.
madam.
Any case pending?
Yes,
This is the latest instruction.
Yes, madam.
So
I'm
I have not obtained that.
You see, Mr. Gogoi is an officer of the court, and this court values the submissions that has been made.
Subject to the outcome.
No,
Let
what
it be
subject
posted
we
after
have?
2 weeks or 3 weeks.
After 2 weeks or
B.
3 weeks.
Gogoi Learned.
Here, Finance Department, yes.
Learned Standing Council Finance submits that the issue that identical issue involved in this writ petition is pending before the division bench of this court.
Got
In do you have the number? In
I
W.
will provide
Can
it.
you provide it?
Yes.
In WA so and so.
In WPC, the rule is under challenge.
In WPC so and so. In view of the aforesaid submission, list this matter. Shall I adjourn it, sign or die?
No, let it be after 4 weeks. In the meantime, we can mention the liberty may be given.
4 weeks on a date to be fixed by the registry.
Number of license.
Deeply obliged.
Mr. Gogoi, please provide the.
I will provide.
Late with the lordship.
Yes.
Lordship, may kindly peruse the last order. In fact, twice opportunity was given to them to file their affidavit, and in the event they fail, then the officer had to be personally present.
Lordship, in this matter, I have filed I have made the affidavit ready and I have sent it for vetting. The problem was, my lord, today is a restricted holiday, so the affidavit could not be sent. My lord. So Monday, I positively, my lord, I'll file it. It's already ready, my lord.
All right. Mr. A. Fukan, Learned Standing Council, Elementary Education.
Yes, sir.
Department submits that the affidavit in opposition. That the affidavit in opposition, though, was ready. However, due to the restricted holiday today, the concerned officer could not come to court along with the affidavit for swearing. Stop. List this matter on Monday.
Monday, my lord.
Obliging.
Deeply obliged.
Lordship, for item number 35, there is interim is there, Lordship.
In item 35, interim, if any, will continue to the next date of listing.
Much
You see, it becomes very, when this court is dictating an order, if you say something, it breaks the flow. So be mindful of that.
Here is item number 36.
No representation.
We need to file our affidavit, Your Lordship. We need to file our affidavit, Your Lordship.
No, but
Instruction is awaited, Your Lordship.
yes, that is all right. But since there is no representation, what is the matter for?
They have filed at the school managing committee of Balipathar Anchalik School, that is under the district of Lakhimpur, resolved to approve a new section in class 10, considering increasing number of students, and approve Shri Deepak Chandra Borwa, that is respondent number 7.
Representation, I'll dismiss it. None appears,
Yes,
for
Your
the,
Lordship.
none appears for the petitioner when the matter is called. Stop. In view of non-representation, the writ petition stands dismissed for non-prosecution.
And in my presence may be recorded.
Yes, yes. Heard so into coordinate disposed of. Contempt.
It is, Your Lordship.
Yes.
The order, Your Lordship,
Yes.
is dated 4/11/2016.
Who's appearing on the other side?
Yes, I am for the respondent. There is a slight development in the matter, Your Lordship. On the last occasion when the matter was taken up, I made a submission before this honourable court that there is an IA which is pending that needs to be connected with the writ petition.
It's not yet connected.
It has not yet been connected. In
All
fact,
right.
the authorities.
I'll direct it to be listed along with the IA.
Yes, I'll be grateful for that.
List along with IA.
The IA has not been numbered as yet, Your Lordship. In fact, we filed the IA. I have provided a copy of the IA to my learned senior friend also.
If it is not numbered, how can I direct it to be listed?
In fact, the IA has been.
All right. As prayed for by Mr.
M. Sharma. Your
M. Sharma, Learned Counsel for the petitioner, list this matter after 1 week.
1 week.
On a date to be fixed by the registry.
Grateful, Your Lordship.
Can we produce the last order?
Yes, what about the Parawise comments?
We
Is it still at the stage of Parawise comments or something is developing?
We had sent it, the reference and the applications. How we stand, madam? How we stand?
As prayed for by Mr. R.M. Majumdar.
R. Majumdar.
R. Majumdar, Learned Counsel for the respondent number.
We stand for all the respondents.
Alright, for the respondent, list this matter after 2 weeks on a date to be fixed by the registry to enable the respondent to file their return in the matter.
Obliged, madam.
Please, Your Lordship.
Yes.
Lordship, here is the contempt proceeding. But
Yes, who's appearing for the contemners?
Lordship,
Yes, Mr. Gogoi.
I need some time also regarding present status, regarding
The 2020 matter.
Lordship, if I may kindly submit, Lordship.
Lordship, there is some issues is there. There is DPC, Lordship.
A new incumbent has joined as a principal Choigaon College, Lordship. Yes, yes. So he has to be impeded, Lordship.
Very well. Your name?
A. Bhattacharya, Lordship.
Mr. A. Bhattacharya, Learned Counsel for the petitioner, submits that a new incumbent has joined the subject post of
Principal Choigaon College and governing body, General Secretary governing body. Secretary governing body.
Principal College, Chaigao College, and as such, an impeding application has to be filed.
Lordship.
List this matter after 3 weeks.
3 weeks.
On a date to be fixed by the registry.
Because I have to give him the representation also. Diploma.
Yes. You were supposed to obtain instructions if this matter has become infraction or not.
They have challenged the Lordship, the order dated Lordship.
No, last time the submission was made.
Page 71, Lordship.
To that aspect,
Yes.
some instruction may be required, but
Yes, you had made this submission way back in November 2020. We are in 24 now. How many more years you need to obtain instructions from your client whether the client wants to pursue the petition or not?
some time may be given. Your Lordship,
This court will accommodate you, but Miss Counsel, please ensure that you have the instruction on the next date, because listing a matter also has a lot of consequences. You see, it has to go from number of stages, and it unnecessarily is wasting judicial time. How much time?
So, 2 weeks.
Your name? MS S. Sharma, Learned Counsel for the petitioner, assures that the instruction as sought for by this the instructions as whether the issue involved in the writ petition is still alive shall be obtained positively within a period of 2 weeks from today. List this matter after 2 weeks on a date to be fixed by the registry.
There is an interim order.
Interim, if any, shall continue till that date. Next date of listing.
May I please, Your Lord?
Instructions?
Yes, my Lord.
Yes, who is going to provide the instructions?
According to the last order, I have to give instruction that till date no salary have been paid to the petitioner.
Have you received the instruction?
Yes, madam. No salary have been paid. And Lordship, I have filed an additional affidavit on 2/4/2024, my Lord.
Yes.
Where if the Lordship will go through the affidavit, it is very much clear that an interim order was passed by this court, and that is on page
110.
1. Yes, 1.0. 1.0.
Yes.
Where it was stated in the paragraph 7, a hearing was provided pursuant to the, I am reading.
Yes, please read.
Pursuant to the order dated 6/12/2019, which resulted in an inquiry, and in the inquiry it was stated that it was revealed that the respondent number 10 has committed certain fraud, and as a result thereof it is also stated that the respondent number 10, Srimati Rahima Khatun, is placed under suspension. We have not been told of any fraud of any nature being committed by the present petitioner, other than the aspect that even after joining in Uttarpanpura LP School, Jala, he has not allowed to discharge his duties. In the aforesaid circumstance, we do not find any prima facie reason as to why the petitioner has not been paid the salary and allowances. Accordingly, in the interim, it is directed the respondent to pay the salary and allowances to the petitioner. It will remain open to the respondent to take note as to in which school the petitioner will serve in either of the two schools if Uttar Panpara LP School Jala create any obstacle to the petitioner in discharging the duty. The respondent through the district elementary education officer shall take an appropriate measure, including providing security to the petitioner for the purpose of discharging duty. After this, the petitioner has submitted before the district elementary.
This is the petitioner in this petition also?
Yes, yes.
So there was already an order for release of salaries.
But till date, nothing has been done. On the other hand, and on the other
Why have you not filed a contempt petition?
Yes, my lord.
You should have filed a contempt petition.
Yes.
This order is dated
24/9/2021. 2021.
I just take a 5 minutes break.
Yes.
Yes.
Lordship, we had filed one stay vacating petition, Lordship.
You have filed one?
Stay vacating petition, Lordship. Against
One
the order.
stay vacating?
Lordship.
Yes. What happened?
Here, Lordship, the petitioner was about to file a reply, Lordship. Here. The last order dated 16/22.
Ms. Counsel, this matter is of 2021. Have you filed your affidavit in opposition?
Yes, Lordship.
Yes. What is your stand? Why is the salary of the petitioner has not yet been released? What is their stand in their affidavit in opposition?
No affidavits have been filed. They have filed in the stay vacating petition.
No, in the index, it appears that sometime in January 2022, on behalf of R4, an affidavit in opposition was filed. Who is appearing for respondent number 4?
R4.
You are appearing for respondent number?
Elementary education, Lordship.
Respondent number?
Yes, my lord. Director Elementary Education, Lordship.
Respondent number, ma'am.
4.
So there is one affidavit filed by your office.
Yes, my lord.
85. What is your stand there? Why are you not prepared? It is very unfortunate that when matters are listed, especially in matters like this where salaries are involved, you don't even bother to look into the file. You're not ready to address the court. How will the court proceed if the bare assistance is not given by the government councils? What is your stand in the affidavit in opposition?
Okay. And their stand in the affidavit in opposition, my lord, as per this, the matter involved in this issue is the mutual transfer. The mutual transfers issue involving the mutual transfer by the petitioner and the respondent number 10, and that issue was already solved by a departmental inquiry, whereby it is on the basis of the report it is established that the respondent number 10 has made some fraud, and thereby he was placed under suspension, and thereafter the petitioner approached before this court, and this court passed an order on 24/4/2021, and he has submitted the copy before the district elementary education officer with a representation. Nothing has been done. In the meantime, they have issued a show cause notice to the petitioner, and petitioner replied to the show cause notice, and thereafter they are sitting over there.
A submission was made that against the order 24/9/21, some stay vacating was filed. Is it correct?
Yes, yes.
What happened to that?
I have filed an objection.
No, that stay vacating is still pending.
Pending, my lord.
the stay vacating application is in this writ petition only.
Yes, my lord.
Which
That
is
order.
that IA?
Stay vacating that.
Which is the IA?
IA is number. This is on file on.
IA 624.
Yes, yes, yes.
Rupak. IA 2 so. 624. There is no order passed in this IA.
Yes, Lord.
Then on what basis have you not complied with the direction passed? You have not even bothered to pursue with this IA after filing. This is not done. There is an order of this court directing you to release the salary to the petitioners. Till date you have not complied with that direction. You cannot simply say that I have filed an IA. This IA has been filed on 1999 in the year 1999.
28/1/22.
No. IA is filed when?
28/1/22, Lordship.
Correct, 22.
22.
So for last 2-3 years, you have not done anything. There is no order also. Is there any order in this stay application?
No, Lordship.
Then why the order of the court has not been complied? Is it the precedent to or does a filing of an IA release you from complying with the orders passed by this court?
No, Lordship.
Then
Lordship, may grant you 1 week time.
very, very, very strange. It is really regrettable. Please write down. Heard MS so and so, learned counsel for the petitioner. Also heard MS so and so, learned standing counsel.
Elementary education.
Elementary education. Stop. MS so and so, learned counsel for the petitioner, draws the attention of this court to order dated 24/9/2021 passed in this writ petition, whereby in the interim respondents were directed to pay the salary and allowance to the petitioner. Stop. Regrettably, the same has not been done till date. MS, next para, MS, your name? So and so, learned counsel for so and so, submits that an interlocutory application being IC number 624 was filed on 28 January 2022 seeking vacation of the said interim order dated 24/9/2021, and accordingly and because of which full stop, it appears that no effective orders has been passed in the aforesaid interlocutory application till date. Stop. Pendency of the interlocutory application for vacating the interim order dated 24/9/2021 cannot be a ground for the respondents to not comply with the orders passed by this court. Stop. A non-compliance of the court's order amounts to willful disobedience by the erring respondents. Stop. However, this court is granting another chance to the respondents to comply with the direction passed by this court by order dated 24/9/2021. Stop. Another chance to comply with so and so within a period of
3 weeks.
2 weeks from today. Stop, comma. Failing which registry is directed to initiate contempt proceedings against the erring respondent. Stop. List after 3 weeks on a date to be fixed by the registry. You first comply, otherwise orders will follow.
May I please, Lordship?
Instructions.
My Lord, yes, in this regard, we have received an instruction here, my Lord.
When you file an affidavit?
Yes, we will file the affidavit, my Lord. Some queries is there, so my Lord, 3 weeks may be granted.
Your name?
U. Sharma, my Lord.
Mr. U. Sharma, Learned Standing Counsel for the Secondary Education Department, submits that he has received the necessary instructions in the matter and accordingly will file an affidavit. Stop. List the matter after 3 weeks on a date to be fixed by the registry.
Much obliged.
Lord, I am appearing on behalf of S.K. Muhammad, senior officer.
Yes.
And he is not
You
well.
wanted to bring some instructions on record.
No, my Lord. Senior is not well, so I mentioned.
Senior not well is a different matter, Mr. Counsel. On 9/2, your senior is S.K.N. Muhammad. S.K.N. Muhammad.
Yes.
There is a prayer on behalf of him to bring further pleadings on record. Have you done anything?
No,
You're not aware.
no.
As prayed for on behalf of Mr. S.K.N. Muhammad, who is said to be indisposed, list this matter after 2 weeks on a date to be fixed by the registry.
Item number 45.
May I please, Your Lordship? Last order dated 19/4/24, the court directed the respondent authorities to bring the instruction. Let them.
Yes, instructions.
Your Lordship, pertaining to that, Your Lordship, communication has been made, Your Lordship.
How much more time?
Your Lordship, 2 weeks time may be
As
granted.
prayed for by M.S.P. Das.
Yes, Your Lordship.
A Learned Standing Counsel for the Secondary Education Department, comma, which is not opposed by the petitioner, list this matter after 2 weeks to file, to enable the concerned department to file their return in the matter.
Deeply opposed.
Item number 46.
May it please, Your Lordship. Lordship, kindly peruse the last order dated 19/4/2024.
Releasing of provisional pension.
they're supposed
Yes,
to
what
release.
happened?
Your Lordship, kindly grant us 1 week time, Your Lordship.
Earlier also,
Yes. It's a serious matter.
direction was given on 15th.
These are matters where livelihoods are at stake. You cannot be withholding it, and that too after orders have been passed by this court. The last order 19/4/24 makes it very clear that if it is not done, consequential orders will be passed.
Then, Your Lordship, Wednesday matter may fixed, Your Lordship. I will try to obtain necessary instruction.
MSP Das, Learned Standing Counsel, Secondary Education Department, assures the court that that order dated 19/4/2024 shall be complied by Wednesday.
No, Your Lordship, at least
By 1 week, within a period of 1 week from today. In terms of the aforesaid endorsement made by MSP Das, Learned Standing Counsel, list this matter after 1 week on a date to be fixed by the registry. Yes.
Much obliged.
Item number 47.
May I please, Your Lordship? Here, my lord, the petitioner has not received her notional benefits from since the year 2016, my
This is
lord.
a contempt matter.
Yes,
yes,
Lordship.
Mr. Chaudhary.
Lordship, here that the Angus Council, Mr. N.J. Khatner and S. Nugi, both are indisposed today, Lordship. So on their behalf, may I pray for next week any date, Lordship?
It is submitted at the bar that the engaged councils,
For the
Mr.
contenders, Mr. N.J. Khatner and S. Nugi, both,
Mr.
Lordship.
S. Nyok for respondent number 1 and Mr. N.J. Khatonia for
Both
respondent number
for
1 are both unwell, are both indisposed today. Stop. List this matter after 1 week on a date to be fixed by the
Madam,
registry.
as a last sentence may be granted, madam.
All right. Next.
I am deeply obliged.
Yes.
May I please, Your Lordship?
Here,
Instructions.
Yes, you have received that. Secretary has already written to the director to send a proposal for
Refunding.
that.
Refund.
Yes, well, that has to be received from the director. Look, it will take 1 week, Lordship, to get that proposal from the director, Lordship. Let it take about 2 weeks, Lordship. In the meantime, that proposal from the director will receive, Lordship, and the necessary sanction will be given by the.
Can it be disposed of with that base or
Not that.
all right.
At the contempt, Lordship, it will take.
Mr. SMT Chisti Learned Counsel for the respondent submits that he has received instructions in the matter to the effect that
The secretary, Lordship, school education has gotten a proposal from the director.
proposal has been sought from the
Director
Office
Elementary
of
Education.
the Director Elementary Education
Yes, Your-
Department.
yes, Your Lordship.
Stop. However, he has not.
Received the same and
However, it is submitted that the proposal is yet to be
received.
Stop. List this matter after 2 weeks
Yes.
on a date to be fixed by the registry for placing of up-to-date status
Yes.
of the proposal in the matter.
Date may be.
That's all right. You will get a date, not to worry. Yes.
Wait, Lordship. Lordship, in this case, I have filed an application for amendment, Lordship.
Mr. Dekka, amendment of what?
No, the writ petition, Lordship. I have basically tried to incorporate whatever their submission was, Lordship, and also extend the prayer portion, Lordship. Lordship, may kindly take up 1977, Lordship. As per
here today, we have filed our objection.
All right.
Objection, Lordship, may...
Anyway, they have filed the objection. It has to come on record. Your name?
P.K. Bora, madam.
Mr. P.K. Bora, Learned Counsel for the respondent submits that affidavit of objection has been filed today. However, the same is not on record. Let registry verify and place the same on record. List next week on a date to be fixed by the registry. Anything, Mr. Dekka?
My Lord, this is of the year 2017.
I've already posted next week.
And bless.
May I please, Your
Yes,
Lordship?
Mr. Thakur.
Lordship, Your Lordship, may kindly take up
Interview.
Interview, Lordship. In fact, Your Lordship, issue in the main writ petition relating to equivalence of degrees of MBA, Master of Visual Arts, and MFA, Master of Fine Arts, Your Lordship. And in if Your Lordship comes to one order, Your Lordship.
What is this IA for?
IA is for allowing the petitioner to appear in the interview to be held
Mr.
on
Mohantal, do you have any objection?
In last occasion, my lord, similar situation order has been passed. So I cannot change my stand today.
No, where is that order?
That order
Page 34.
34.
Starts from 33.
His degrees in master in visual art, and whether visual arts and my lord, fine arts are same or not, that has to be my lord clarified by the government, not by the APS. We have to go by the advertisement. In the earlier occasion, he was allowed to sit in the examination, but subject to result of the repeat.
And the results shall not be declared without para 9, Your Lordship.
Page 34, my lord, has your lordship got it?
Yes, yes.
Page 36, my lord, para 9 is the 11th question.
So they already appeared, permitted to appear.
In similar other advertisement, my lord.
Very well.
My lord, here also.
We can dispose of the
My lord,
parliamentary application.
But that handle should be given.
Yes,
Subject
Para
to
9, Your Lordship.
his my lord result should be declared subject to outcome of this.
However, you want this last portion to be incorporated. However, the result
Same,
of the
but yes,
petitioner shall not be
same
declared
every-
without the permission of this
My
court. All right.
That,
We shall refer to this this
Yes,
order.
exactly, exactly.
Heard Mr. S. Borthakur, learned counsel for the petitioner. Stop. Also heard Mr. T.J. Mohanto, learned senior counsel, assisted by M.S. P. Sharma, learned counsels for the respondent.
Respondent number 2, public
Respondent
APS.
number 2 and Mr. Elementary, anyone there, Mr. Chiste? Elementary? Is elementary?
no, we have not made elementary as part.
But the
Higher.
presence is required?
Lordship, that issue was raised, your Lordship. The Honorable Court in earlier order said that that will be not be decided.
All right, since they are not respondent, then are you a respondent here?
Yes. Higher than a respondent.
So, Mr. Rupak, tell us about naam loi lo. Mr. Gogoi, but they have arranged you as a respondent. I'm recording your name. Are you want your name to be recorded, or you don't want your name to be recorded? Indicating. In the writ petition, you indicate whenever. Very well, Mr. Gogoi. Next time when the writ petition comes, you inform. And Mr. Borthakur, you take steps to array the party which is essential. Why unnecessarily? Then I'm striking off in the writ petition. Pathamat in the writ petition lekha.
Lordship, there is an order by the Honorable Justice to run on this, your Lordship, page 38.
That they are necessary party?
No, it says, your Lordship, it is submitted that the issue can only be decided in presence of the state. Therefore, the issue relating to whether higher education is a necessary party is left open to be decided during the hearing. I will also make necessary.
For today, I'm just recording your presence. Alright? IA to Diba. So and Mr. K. Gogoi, learned, standing counsel, higher secondary education. Higher education. So much of confusion with the names of respondents that I have already forgotten what I am supposed to order. This is an interlocutory application seeking an interim order directing the respondent Assam Public Service Commission to allow the petitioner to sit for the viva voce examination in connection with advertisement number 20 of 2022 dated 13/9/2022 for appointment to the post of lecturer in Earth Education in DIET under the Directorate of SCRT, Assam. Stop. It is submitted at the bar that the prayer sought for in the interlocutory application is covered by the order of this court dated 26/7/2023 passed in WPC 4114 of 2023. Stop. In view of the aforesaid endorsement made by the learned counsels for the parties, this IA can be disposed of similarly. Stop. Accordingly, this court directs in the interim, more particularly the Assam Public Service Commission, to permit the petitioner to appear in the interview with regard to the advertisement number 20 of 2022 dated 13/9/2022, which is scheduled to be held on
3/6, your Lordship,
2024. Stop. However, the result of the petitioner shall not be declared without the permission of this court. Stop. Do you want a copy of the order? I think online it's available. So the IA stands disposed of. IA stands disposed of.
Supplementary item number 60.
I'm sorry, my lord. In this case, lordship, there is no mistake in the lordship order, but it is in the typographical mistake in the pull of the name of the petitioner, my lord. Wife of the son of this, like, page 7, my lord, in I am, my lord. Golab Das, page 7.
Yes.
Prayer portion. Golab Das is woman, that's why, my lord. Wife of late Horen Chandra Das, but instead of it has been typed, my lord, son of.
No. Correction of relationship of the said petitioner number 3, wife
Yes.
of so and so instead of son of.
Yes, my lord.
In the order where it has come.
Oh, yes, in the order, my lord, 3. Padmaram is also there. It is typed as Padmaram.
Where?
Page, my lord, 9.
In the order.
Order, my lord.
Page
I
9.
have annexed here, my lord, photocopy.
You see, how can this court correct your cost title?
Then
There is nothing. There is no
it is
error
not a wrong from
in
the
the order
court
of the
side.
court.
The Padmaram is typed out by the stenographer, my lord.
Is it, Mr.
Padmaram is
Gogol?
not there. Post.
No, your prayer says Golab Das is son of, which should have been wife of. This is what is there in the writ petition. Writ petition to Asanigi.
Yes.
Please give the writ petition. Do you have a copy, Mr. Gogol? Please check the writ petition and see whether Golab Das has been said as son of or wife of.
Hey, wife, son of.
Golab Das
Is son of?
It has to be wife of.
They have written in a tribe.
Correct. Then how can this court correct? Sorry.
Correct son of them. Otherwise,
And son of them. Stenographer type is as Padmaram.
No, but you want that.
Stenographer type is as Padmaram.
It should be what?
It should be Horen Chandra Das, wife of Horen Chandra Das.
Is it correct, Mr. Das? Mr. Gogol?
Lordship, it is there, Lordship. No repetition there. It is not the part of the stenographer. Yes, because Lordship, when the matter was uploaded in the registry, that time Lordship it was done.
No, Padmaram is the petitioner number first. The petitioner number 1's father.
Counsel. You see, you are asking this court to make a correction. Now, this court can make a correction if there is an error in the body of the court's order. It appears that this application has been filed for correction of typographical mistake in the cost title of the order dated
10/5/24.
10/5/2024. Stop. There being no error in the order of this court, no correction from this court is warranted. Stop. Accordingly, the present IA stands dismissed. However, needless to clarify that the applicant is at liberty to approach the concerned registry for correction of the cost title in accordance with cost title. Stop.
61, my lord, year of the repetition, my lord, it is wrongly typed. Year, in first one, it is, my lord, 4594, last but 3 above paragraph, my lord, 1, 2, 3, 4, 4th paragraph. WBC 4594.
Yes.
It is, my lord, last in the last 220222, but it has to be, my lord, earlier it is mentioned correctly, my lord. Paragraph 2, WBC 45, page 7.
It should have been 2020.
Yes, my lord, that is only.
Okay. This can be done.
First page it is correct.
Correct. After that, by mistake, it has come 2024. This application has been filed for correction of typographical mistake occurred in the order dated 17/5/2024 passed by this court. Stop. It is being pointed out that in para 3, no, not para 3, in para 2, para 2 also.
Yes,
correct?
Correct is para 2.
No, what, you see, I think, counsel, there, that 4594/2020 is Vrindavan Chaudhary's case.
Yes.
What about Sashadhar's Shil? Is it, I think that is 1374 of 2024.
Yes.
So that is correctly said in view, similarly stated to the petitioner, 1374.
Lordship, the paragraph 3, Lordship, kindly peruse last 2 lines. It is 4594/2022. It should be,
That is
2022.
2022.
Lordship, 4594/2022 should be 2020, Lordship.
Okay.
That is in paragraph 2, Lordship, it is correctly.
So that is the correction.
That is the correction.
It has been pointed out that in paragraph 3 of the order WPC 4594 of 2022 has been inadvertently inadvertently typed, while it ought to have been WPC number 4594/2020. Stop. Accordingly, the interlocutory application is allowed. And the order dated 17/5/2024 in para 3 WPC 4594 of 2022 shall now be read as WPC number 4594 of 2020. Stop. Allowed. That's all, right?
Yes, sir. That is correct. I level it.
Allowed. This is that royalty matter. I think, Mr. Borpujari, you were supposed to enlighten the court as under what authority royalty.
Yes, absolutely.
Only thing, will you be taking time, because this court will not be available from tomorrow, from next week.
Half an hour, but
all right.
Make an attempt. I will try to cut short as possible. If Lordship is to be pleased to take up the Constitution.
Have you taken this? Yes.
Now, the admitted position here is that, my lord, there is no specific regulation or legislation by dint of which royalty has been imposed or the practice of royalty was done. But there are executive instructions. Under that circumstances, a question was posed by the Honorable Court that under what authority are you imposing the royalty? What is the source of power? If my lord may be pleased to come to Article 162 of the Constitution.
160?
162. 162, my lord.
Yes.
May I read it, my lord?
Yes, please.
162. Extent of executive power of state. Subject to the provisions of this Constitution, the executive power of a state shall extend to the matters in respect to which the legislature of the state has power to make rules, provided that in any matter with respect to which the legislature of a state and the parliament have power to make rules, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or by any law made by the Parliament upon the Union or the authorities thereof.
So
here
so the condition is that legislature of the state has to have a power. In that case, the executive power of the state can be extended.
Yes,
Correct?
now that is the precise meaning falling out, my lord, from a bare reading of Article 162. Subject to the provisions of this constitution, the executive power of the state shall extend to the matters with respect to which the legislature of the state has the power to make laws. Now, Lordship may be pleased to come to, my lord, Schedule 7, that is List 2, the state list.
Yes.
The state list.
Schedule 7. Just a second,
Yes.
Mr. Gorpujari. Yes.
The state list, my lord, enumerates various situations and, my lord, the parameters under which, my lord, and broad headings whereby the state is empowered to make rules. Lordship may be
Seven schedule.
7. Otherwise, my lord,
List 2.
List 2, state list. Because Lordship is ever, my lord, there are 3 lists, my lord.
Yes.
List 1, union list.
One second.
Yes.
In list 2, which is this?
Yes, list 2, Lordship may be pleased to come to entry 24.
Entry 24.
Yes, my lord.
Industries subject to the provisions of entry 7 and 52
subject to the provisions of entries 7 and 52 of list 1. Now, entry 24 says that the state is within its domain to make laws with respect to industries, even except, my lord, what has been provided for entries 7 and 52 of list 1.
No, just 1 second.
Yes.
7 and 52.
7 and 52 of list 1.
Yes.
Now, if Lordship turns to list 1,
yes,
and maybe pleased to come to entry number 7.
Yes.
I am reading it, my lord. Industries declared by Parliament by law to be necessary for the purpose of defense or for the prosecution of war. And then 52.
How is 7 relevant?
7, because, my lord, there cannot be any repugnancy between union list and state.
No, I'm not saying that. Now, under the state list,
Yes.
you are relying on entry
24.
24.
24,
correct?
yes.
So, 24 says industries subject to provisions of entry 7 and 52.
52 of list 1.
Of list
meaning,
1.
meaning thereby that the state can make laws with relation to industries, but subject to 7 and 52.
So, there is an exception.
Exception. That exception. Now, 7 says, my lord.
Understood.
Yes.
Industries which are necessary for defense and war.
Defense and
So, that is
definitely, my lord,
excluded.
the parliament is within that
So, state,
domain.
will
State
not-
cannot, my lord, step in, my lord.
And also
then
52, which is for public interest, control of which.
Public interest, industries, the control
So,
of which.
according to you, brick clean is not an exception.
Brick clean is not an exception. Brick clean, my lord, it is an industry, my lord, which is carried on state work. For the purpose in the state
So,
of
by this, you are showing that state is competent
competent
to impose tax by way of an executive instruction.
impose royalty.
Royalty.
Now, there is a distinction between tax and royalty that I will, my lord, try to persuade, my lord.
Okay.
My lord, I am placing 2 decisions of the Honorable Apex Court. If my lord may be pleased to.
Yes.
If Lordship may be pleased to take up the first decision, my lord, of 1968, Sant Ram Sharma. Sant Ram Sharma, that is, my lord, AIA 1967 SC 1910.
Yes. Para 7.
Para Lordship, thereof, Lordship may be pleased to come to Para 7 and Para 8.
Yes.
This was with regard to, my lord, a service matter. My lord, whether under the provisions of Article 309, in that faction situation of that case, my lord, whether the state of Rajasthan had the power to frame rules. Paragraph 7, my lord, I am reading it quickly. We proceed to consider the next contention of Mr. So-and-so that in the absence of any statutory rule governing promotions to select grade posts. The government cannot issue administrative instructions, and as such administrative instructions cannot impose any restrictions not found in the rules already framed. We are unable to accept this argument as correct. It is true that there is no specific provision in the rules laying down the principle of promotion of junior or senior grade officers to selection grade posts. But that does not mean that till statutory rules are framed in this behalf, the government cannot issue administrative instructions regarding the principle to be followed in promotions of the officers concerned to selection grade posts. It is true that government cannot amend or supersede the statutory rules by administrative instructions, but if the rules are silent on any particular point, the government can fill up the gaps and supplement the rules and issue
This is in the context of promotion.
Promotion, but my lord,
You're drawing the analogy.
The contention that I am trying to bring home, my lord, is that, my lord, the state is empowered to make rules if the source of power is already there. Now, I have shown, my lord, that the source of power is already there in NP 24. Bricklane is an industry. There is no denial to that fact. So, therefore, even if there is no statutory, my lord, legislation as on today standing or in existence that the state government of Assam can impose royalty or in any other manner, then, my lord, by issuance of executive instructions, still, my lord, rules are being made, this practice has been followed, and this practice has a constitutional, my lord, mandate. I am not drawing, my lord's attention to paragraph 8, it is just a repetition. Now, my lord, so far as royalty and tax, what is the distinction? That lordship may be pleased to take up the second decision. It is a landmark decision, my lord. In Steel Hydropower and Manganese Limited, that is 2021 10 SCC 165.
Yes.
Their lordship may be pleased to come to paragraph 48.
Yes.
Although I am relying from paragraph 48, lordship may directly come to paragraph 50, to be precise. Paragraph 50. May I read it, my lord?
Yes.
In the state of so-and-so, another constitution bench of this court explained certain observations in India Cement Limited and stated under. First, we will refer to certain dictionaries cited in courts of law. Words and phrases. Royalty. Royalty is the share of the produce reserved to the owner for permitting another to exploit and use property. The word royalty means compensation paid to landlord by occupier of land for species of occupation allowed by contract between them. Royalty is a share of the product or profit as of a mine, forest, etc. reserved by the owner for permitting another to use his property. Then, my lord, the next page, classitum A, my lord. The word royalty signifies in mining leases that part of redundum which is variable.
Where, Mr. Barpujari?
My lord, page 203, classitum A, my lord. I have just now read, my lord, page 202, classitum D.
Yes.
Now, classitum A.
Stroud's dictionary. Yes.
Stroud's judicial dictionary of word phrases. The word royalty signifies in mining leases that part of redundum which is variable and depends upon the quantity of materials gotten or the agreed payment to a patentee on every article made according to the patent, rights or privileges for which remuneration is payable in the form of a royalty. Then, my lord, next, a royalty in the sense in which the word is used in connection with mining leases is a payment to the lessor proportionate to the amount of the demised material work within a specified period. Then, my lord, Wharton's law lexicon. Royalty, payment to a patentee by agreement on every article made according to his patent, or to an author by a publisher of every copy of his book sold, or to the owner of minerals for the right of working the same on every ton or other weight rate. Then, my lord, Mosley and Whiteley's Law Dictionary. A pro rata payment to a grantor or lessor on the working of the property lease or otherwise on the profits of the grant or lease. The word is specifically used in reference to mines, patents, and copyrights. Then, my lord, French Judicial Dictionary. Royalties are payment which the government may demand for the appropriation of minerals, timber, or other property belonging to the government. Now, land belongs to the government. Two important pieces of royalty have to be noticed. They are that the payment made for the privilege for removing the articles is in proportion to the quantity removed.
Basically, royalty is a rent. This is what it is.
Yeah.
You can straight away come to para 51.
Para 51.
205, I've read.
Yes, my lord.
Yes.
Before that, my lord, at page 205, if lordship is taking
I'm
up
at
para 51,
205.
yes, prior to that, my lord, classicum A, if I may read it, my lord.
Yes, I've already read it, but
Yes,
you can for your
yes,
satisfaction.
the apex court has held that we hold that royalty is not tax. Lordship may kindly mark it. Royalty cannot be taxed.
That is also there at 51 subpara 46.
Subpara 46.
I've read
so,
it.
so this is my precise argument. I will not take lordship much
So
of
for,
the time.
according to you, this is the rent for
Yes.
the land which is being used. That is royalty.
It's a payment, my lord, for extraction and causing, my lord, when, my lord, the land value is deteriorated.
Very
And the answer to this, my lord, on the fact situation, at paragraph, my lord, 12 of our affidavit in opposition. Why this has been issued, my lord?
Mr. Borpujari, please provide a one-page
Yes.
kind of a note.
Yes, yes.
Because what happens by the time I'm going to look into the file, it becomes very difficult. Just one page. Mr. Saikya, you also give up one page. But yes, you were showing something. You
Yes, yes,
show it,
yes.
and then I would
Yes,
like
yes.
to ask something
Yes,
from the
yes,
other
my
side.
lord. If my lord may be pleased to come to running page 95 of the paper book, my lord. Running page 95.
Yes.
That is a part of the affidavit filed by the Revenue Department.
Yes.
Now, for what reason royalty has been, my lord, imposed? The answer is at paragraph 12. The deponent states that the royalty on brick cleans have been directed to be collected by the Revenue and Disaster Management for the art used for the brick clean and the gradual loss of productivity of the land due to establishment of brick clean, making it unfit for agricultural purposes for years to come. Over continuous use of land for brick clean industry, the land can only be utilized for fishery. So the value diminishes. So therefore, my lord, I am entitled and I am within the jurisdiction, my lord, to impose royalty. This is my humble submission.
Mrs. Saikya, there was, I'm subject to correction, I thought there was a decision of the Apex Court maybe in the 70s where in respect of royalty also there was some...
Yes, yes.
Do you have it?
India Cement, that case method, there it has been held that royalty is a tax. But then again, subsequently this decision, what has been read, it says
it's not a tax.
Yes. Ultimately, a full bench has been already heard the matter, judgment is awaited. Yeah.
Oh.
Because
Judgment is awaited?
It's awaited. So far, there's no stay as such. My whole case is something on a
very well. You anyway.
Yes,
you
it's
give me
on a different footing, here. What the provisions of constitution that has been sought, that is basically the power of the executive to frame rules where the state has the power and no laws has been as such made. But
if a substantive law is not there.
Not there. So therefore, in the time till the law is framed, this has been they have that particular regulatory measures taken at it, but not for imposing royalty. Now the argument that has been placed here, you find there's a confusion. The judgment that has been read, it is said royalty can be imposed on the minerals,
on the land minerals,
lands, etc.
Basic idea of royalty is that it is for the use.
Royalty
this
basic
is the idea
something
which is
I have
coming out from those decisions, that it is for the usage. Since you are using the land, you are extracting something from the land. Therefore, you are paying a royalty, which otherwise is like a rent.
Yes. But that thing,
unlike
has
tax,
to
tax is not because of the use.
Yes.
Tax is, my lord, it is the general burden. I pay tax, my lord, without
liability.
Yes, my lord, without there being any expectation from my side, my lord, that I will be subject to this benefit only. But here, because India Cements, my lord, have been distinguished here in 2021 decision.
Which paragraph?
My lord, India Cements, lordship will find that, my lord. So, I am reading it.
Anyway, Mr. Saikya, you can complete.
This the same very judgment had been referred to the larger bench, and this has already been heard. The judgment is away. That is on different method. The Lord would like to raise on it.
You have something more, or you're already finishing?
I'm totally different. I am not saying that they are not.
No, I'm saying, are you finishing, or we will otherwise we'll resume at 2?
We'll resume at 2.
In India Cement distinction lordship will find at page 205 of the decision. It's a part of my lord paragraph.
205.
Yes, paragraph 50.
Okay.
I'm so obliged.
And there is no laws by which regulates the brick industry. So therefore, in absence of any rules as such, the state has the executive has the power to make the rules or whatever the executive inspection. That is one limb of the argument that we made. So that is what they are referring to of the notification of 2001.
Yes.
I'll take your lordship to that notification. And secondly, the judgment which has been relied on, that is with regard to the minor minerals, royalty on minor minerals.
Yes, yes.
So, in that sense, it is said royalty is not a tax.
In the context of that case.
In context of that case. Now, so far as the royalty is tax or not, well, the 7 judges bench in that India Cement case, 1990, 1 SSC 12. In para 34.
Sorry.
1991 SSC.
1990.
1 SSC.
Yes.
Page 12.
Yes.
India Cement Limited. In para 34, it is said royalty is a tax.
India
Cement Limited versus State of Tamil Nadu.
I think you had handed over a copy.
List of books I have given, but not the copy.
Is there? Yes, India Chemical. 1991.
1991 SSC page 12.
1991 SSC.
1990 volume.
Yes.
Volume 1 SSC.
Synthetics and chemicals.
No, India Cement Limited versus State of Tamil Nadu. 1990 volume 1 SCC page 12.
Page 12.
Page 12.
I think that has not come.
Synthetic, we have also referred to synthetic.
List of books are 9.
Yes, madam.
Mr. Saikia, it is not provided in the list of book given by your junior. Yes, you may have a look, Lydia.
Sorry, madam. They have given a difference. I'm sorry, madam.
It should have been given in the list. What is given there is some 109.
109.
He's given a print of that.
We are also referring to that also.
Anyway, but this citation is not. No, I think it would have been appropriate if a photocopy was there. How long is the judgment?
This is just I'm referring because what is the status of this particular question?
Print data uliya diba na? Yes. Royalty is a tax.
Royalty is paragraph 34. But this again came to be considered, my lord, in a subsequent, my lord, case. 2011. These are not, my lord, given as a, my lord, a list of books.
Here also it is said royalty on mineral rights is not a tax on land, but a payment for the user of land.
Yes, that is the meaning.
Now here it is brick clean.
They are saying brick clean, which is completely owned by the person concerned, the owner. They don't part anything with us. What they part is with the brick art, that minerals. And
there is no use of land.
There is use of land, brick art, in the form of brick art. But so far as the brick clean is...
Let me understand. Suppose you are manufacturer of brick clean. You will purchase a plot of land.
Yes, it's my own.
It's your own land.
Own land.
In that land, you will manufacture brick clean, isn't it?
Brick.
When I make
brick.
Correct.
For that, I'll have to collect.
You will collect it and bring it to your land. Here there is no use of land.
No use of land. For the purpose of making the brick, I have to collect brick. So that it may be from the own land, it may be from different land. But since it falls under the minerals, minor minerals.
What I am saying is that ultimately after you collect the materials, you will procure it where? At the land that belongs to you?
Yes, sir.
Not in somebody else's land, generally.
The brick clean, for this particular case, the brick cleans are on our own patta land. Okay. We also procure the brick art from the patta land of our own or from someone else.
Okay.
So there is no question of parting something of the which belong to the government for the use.
Okay.
So far as the art is concerned, that as because it comes under minor minerals. Under the Assam Minor Mineral Concession Rules 1994, earlier than 2013, there is a provision for imposing for payment of royalty. And we are paying it.
That you are paying?
We are paying.
Where in the petition have you said all that?
Yes, in the petition we have said.
Where, which para?
Yes. The actually is such, initially there was no law. Nonetheless, they have been realizing royalty on the brick art only. Brick art 2.50 rupees. Brick art they were imposing. There was no law as such because though the Mines and Regulation Act under that specific act is there that the state government can make rules for the purpose of minor minerals. There was no such rule has been made by the state government. Nonetheless, they have imposed this 2.5 rupees on the brick art. We had been paying. Then 1994 rules came. There specific provision has been made for realization of royalty on the brick art. But the authority has been described under the Mines and Mineral Concession Rule that brick art, for the purpose of brick art, royalty will be realized by the Forest Department. And so there is two schedule under that rule, X and Y schedule. So far as Y schedule is concerned, the royalty will be realized by the Forest Department.
That you are already paying.
Initially, we did not
now
pay.
Now you are paying.
Now things so happen, my lord. 94, the rule came. The Forest Department did not realize. The Revenue Department has been realizing this royalty. We have been paying because now we are sure that they have the authority to realize the.
That is different than from what is now sought to be levied.
It is the same now.
Look, Mrs. Aika, I am slightly getting confused now.
Look, yes.
You see, because facts is something which you will know. I will not know.
Yes, exactly.
Now, the impression which this court was having from the beginning is that there is no provision for imposing the subject royalty. In fact, Mr. Borpujari fairly concedes that part. However, he showed that there is a power. This was his argument. Yes. Now you are also trying to make an argument that under the provisions of the minor mineral concession rules, there is a provision for imposing royalty, and that you are paying. So that is what has been what is challenged here, or that is something different.
that, my lord, since
you are confusing me. I am not.
no, since the royalty has been realized by the
Correct. So therefore, the royalty on the earth is different. That they are already paying. Correct. That is a different aspect. But that is not
so
something
now
I am trying.
yes,
to
that's
ask
what.
you.
It's
not relevant.
It is not a lease.
Correct.
It is not a lease
Mr.
here.
Saike, I think we are slightly going out of context.
No,
I'm
I'm
getting
not.
confused.
My lord,
My specific query to you is that because referring to that India cement decision, it distinguishes the royalty, right?
Yeah.
The tax and royalty. They say it, that royalty is not a tax. But what they try to say is that when you're using the land, now that is why I was trying to ask you, in your case, you are a manufacturer of bricklane, you are doing bricklane business, and you do it in your own land, irrespective from where you bring the art. That is different aspect.
Yes.
Isn't it?
Yes.
Now, when you are doing the manufacturing of bricklane, at that stage, they are trying to impose a royalty. Yes.
Royalty.
That is which is now the subject matter.
Yes,
Have I understood it correctly?
Exactly, Mr. No, my lord, this has been clarified just now by them only because
Yes.
the argument, that's what at the beginning I said, my lord, they are saying that they are realizing royalty on brick cleaning as an industry. There is no law as such. Now the judgment that has been cited, it is with regard to the minor mineral to contend that royalty is not a tax.
Yes.
Well, two is different. Well, royalty is totally different. Well, realizing on the royalty on minor minerals is something different, and royalty on the brick cleaning is something different. So now they are saying that this royalty is on the brick cleaning.
Okay.
So far as the brick art is concerned, they also agreed that we have been paying to the forest department, and the documents are also annexed that we have been paying on the brick art. Now, whether on the brick clean they can realize royalty, that too without there having any law, and they just merely saying that as because there is no law, the executive power extends to that extent. So which notification says so, except this notice that has been issued to us, there is no such notification by which they can contend.
They have referred to provision of the Constitution.
My lord, we have annexed all the relevant notifications in our affidavit in opposition. It is already there.
Yes.
So once my line is senior college.
Mr. Varpujari, just provide all that information in that note.
Yes, definitely. And Lordship will kindly take a note of my lord, Article 31A. If for a moment.
Article
31A. 31A of the Constitution, my lord. Because big cleans, they are being operated on the strength of lease. The lease is given by the government.
No, that is why I am asking whether this land are their own land or what land.
Yes.
But Mr. Saikya is saying it is their own land.
Own land.
Patta they are, patta
Own
owner.
land or my lord, in sometimes my lord, in government land also. My lord,
That
the
would be
government.
different. Here the petitioners are the patta
Patta
holder.
land, but they are operating by virtue of lease.
No, not at all.
Virtue
Lease of
Not at all.
lease of my lord big claim.
No, not at all.
This
This is not pleaded case, nor our case.
No, Mr. Varpujari, lease for what?
Lease for my lord running the brick claim.
Running the brick lane.
Yes.
But the land is their own. Then why did they need a lease?
No, he needed a lease because my lord,
He might need a license.
he need a license. My lord, yeah, license, my lord. In some cases, my lord, the authorities issue license. Some cases,
The
my lord,
issue is
authority-
getting complicated for me right now.
My lord-
Because, you all are making it, I thought it was a very simple issue. It is suddenly becoming very complicated. How can a lease be granted to him on his own land?
My
What
lord-
is this argument?
Yes.
I'm sorry, I'm not being able to follow it.
Yes, no, my lord, I'm clearing it. My lord, so far as my lord, government lands are concerned, I'm making a wholesome argument. My lord,
No,
there-
but Mr. Varpujari,
Yes.
let us confine to the petitioner's case. In the case of the petitioner,
It is
he
the
is
man-
the pattadar.
He is the
What
patta.
lease do you need to give him? For what?
Because, my lord, he is operating an industry. He is operating an
So for
industry.
operating an industry, do you need a lease? or you will need a NOC or a license.
NOC license, whatever
So
it is.
then
Yes.
these all it
No.
has its own
Yes.
meaning. You cannot use them as misnomers.
Yes. Now, my lord, why I am making these submissions? Because this is the second round of litigation. In the earlier round of litigation, where, my lord, the Association of Brick Fleet Owners came up before this honorable court, and there was a consensus between them. And it is the admitted fact that the petitioners herein are members of the association.
What was the consensus?
Concession that, my lord, they will give rupees 10,000, my lord. It is a concession.
Where is that order?
Yes, that order. Division bench order. Proceed may kindly come to my lord, running page number 109. Running page number 109.
I think last time I had seen it.
Yes, yes.
109.
109. That is the part of the affidavit, my lord, filed by the department. Annexure F.
Yes.
I am reading it, my lord. The only grievance of the petitioner is that the demand of rupees 25,000 per annum or by way of royalty is not justified. The respondents have filed an affidavit dated so. In the affidavit, respondents have stated that the association of which the petitioner is member has agreed to pay rupees 10,000 per year's royalty instead of rupees 25,000 per year. Learned Additional Advocate General says that the matter is being considered and hopefully it will be decided in favor of the petitioner and their association. In the circumstances, Learned Counsel for the petitioner does not raise this petition and the same is accordingly dismissed and not raised. So this was the finding. And after this, my lord, the order, division bench order of this honorable court, my lord, this letter at page number 111 had came to be issued, which is now put to challenge by them. So my humble submission is, my lord, they are now estopped. The principle of estoppel will operate against them. They are now estopped from raising that submission. Irrespective of the fact whether the state has the power not that this. They had, my lord, before this honorable court, given an undertaking. They had, because at one point of time it was 25,000. That was put to challenge. How 25,000? Then they say, my lord, that the petitioner respondents have stated association which has agreed to pay. They agreed. And they made that consensus, my lord, that concession before the honorable division bench. And now this is a fallout. Page 111, which has been put to challenge, is a fallout of, my lord, this order. This order is dated, my lord, 7/9/2010. They now cannot resile from it, my lord.
Your affidavit is that respondent number 3, no?
Yes, my lord.
That is you, right?
Yes, my lord.
And Mr. Gogoi is 7.
Gogoi is 7. My lord, my affidavit is, my lord, respondent number 7.
You are 7.
7.
You are for 3. Yes.
Yes.
Because there are 2 affidavits, one from 3, one from 5.
Yes. Now 7, my lord, is the government. It's the department whom I am representing. Revenue department.
Well, you file your respective written arguments. Yes, Mr. Saikia? You want to argue more?
Nothing has been cleared as so far, my lord. What they have been saying, it is not in their pleading nowhere, my lord.
No,
but first thing, yes. No, I'm coming to that, my lord. What is their pleadings?
They have made their argument. If according to you that is not in the pleading, you point out.
No, my lord, what they have argued, my lord, so far as the first opening, what I have understood, my lord, that they are trying to realize royalty on brick clean, as because it is not, it is an industry and there is no law, so therefore they have the power, executive has the power to realize royalty on industry.
Yes.
That is what I understood first. But all along, from the beginning, what they are pointing the division bench, etc., all along, it was the royalty on brick art from the beginning. And they are now trying to, by showing that judgment of the order of this division bench.
You are also agreeing that under the Minor Minerals Concession Act, they are empowered to levy royalty.
Exactly.
So then?
Since till 2013, they were not realizing, the authority for realization of royalty is the Forest Department under the Assam Minor Mineral Concession Rules. till 2013, they did not realize. And we know that government has the power to levy royalty on minor minerals, that is the brick art. The question of brick clean had never come up. Till 2013, the Forest Department did not realize. Now 2013, the Forest Department has started to realize the royalty, and we have been paying to the Forest Department. So we stopped paying to the Revenue Department. Now, therefore, the notices have been issued that you pay. So we said, now what is your authority? Earlier question was this, that the government has the power to levy royalty on the minor minerals, and the power has been given to the Forest Department, but the Revenue Department is realizing. So there is no question of challenging that, because sources of power is traceable. Now the Forest Department is realizing the royalty. Definitely there has to be, beyond the Assam minor concession rules, there must be some other source which empowers them to realize royalty on brick clean.
Yes.
Now, royalty, as they have also said, I have also judgment to show that
That's all right. Let's not.
Yes, for the purpose of
repeat the argument.
No, for the purpose of
what about the concession made before the division bench? What is your reply to that?
Yes, my lord, that
Because
was.
you are a member of that association.
I was a member of that. We have given a concession because suddenly,
from 25 to 10.
Suddenly from 7,000 to 25,000 they have made.
You were agreeable to 10,000.
10,000.
And they have made it 10,000.
10,000. But the Forest Department was not realizing the royalty. Now law has been changed. Now the law which has the Assam Mines and Mineral Concession Rule, the Forest Department is now realizing.
I'm sorry, I'm not being able to appreciate this part of your argument.
Department takes its regarding respect of ordinary art cutting. In art cutting, there is a provision for taking the royalty, but there it's a big different thing.
So for brick clean, there is no provision.
Brick clean lordship, as per the consensus of division bench lordship, they have to pay 10%.
That I've understood.
On the basis
but
of the
otherwise, under the minor minerals,
it is ordinary art cutting lordship.
That is ordinary art.
It was also settled by the Honorable High Court. Our division bench also settled that lordship.
That is the 2013 rules.
Even lordship, the Pattal and also lordship, they came.
But that is restricted only to the ordinary art.
Ordinary art cutting. Even my lords, even Pattal is there, then also lordship, ordinary art cutting part.
Royalty has to be given.
No, my lord.
And here the issue is brick clean.
It is brick clean. And this process has started way back since the year 1984. Because lordship will be examining the decision making process under 226. So we have to place all the cards before the Honorable Court. So accordingly we have placed everything. How, my lord, this came to be issued, this impugn letter, my lord, of 5th June 2014. What is the culmination? What is the genesis? Yes, everything, my lord.
5th June?
5th June 2014.
Where do I get that letter?
Lordship will get it at page 111. It's a part of my affidavit. It is also a part of the repetition. Lordship takes up my affidavit.
Yes, I have.
Yes, my lord. Running page number 111.
Annexure G.
Annexure G. And in that very affidavit,
royalty of brick clean.
Yes. In partial modification of government circular mentioned above and in supersession of all other previous government circulars.
This came after the concession.
This came after the concession. And prior to that, what was the situation prevailing? That lordship will find it from page 97 onwards. I am troubling my lord with all these pages, my lord.
No.
Page 97.
So the metal
before I'm dealing, since I'm dealing with it, it has to be clarified.
Page 97. Annexure A. Page 97.
Yes.
Annexure A. This is the first document in our affidavit. Now this is dated way back in the year 1984. Kindly see, my lord. It is to all the deputy commissioner. It is issued by the Revenue Department. I am directed to say that it has come to the notice of the government that there has been haphazard growth of brick industry and many of the industrial units are using land from government VCR, and government khas land without valid permission from competent authority, the matter of realization of royalty and laying down terms and conditions for granting lease of land for manufacturing bricks. That is why, my lord, I have made that
No, Mr. Barpujari, I have some reservation here because the object appears because there are some certain category of people who are using government land without valid permission. Correct?
Right.
Now, here the petitioner, according to them, they are not one such category. They are the patta, they are original. So therefore, when you are levying this royalty with this object, will it be fair to impose it on them as well? Because it is their own land.
Absolutely. My submission will be, my lord, apart from this object, there are other objects. Lordship will kindly speak. If I may read this document as well as the subsequent document.
Yes.
The whole, my lord, process. After careful consideration, I have now decided to lay down a policy for granting lease for manufacturing brick clean tiles on government lands only for 3 years to so and so private individuals, the period of lease and so. So this is with regard to government land, as rightly pointed out by my lord. Now, lordship will kindly come to, my lord, page 101. Now, this has taken a turn. Page 101. This is 1986. Restriction of brick industry on land.
This is setting up of lands which are suitable for agriculture.
This is the reason. This is the reason.
The last line is important. It is clear. It is
No,
also
I
clarified
am
that
directed
no
to say-
license is required for setting up brick kiln on one's own field.
No difficulty. I am directed to say that it has been observed that some brick kilns have been set up on lands which are suitable for agricultural purpose. Considering the importance of agricultural land, the government have decided that no government land suitable for agricultural purposes will be allowed for setting up.
Again, government land.
Government land. It is also clarified that
This
no
is not
license.
a case where he is using it is a government land.
Yes.
Barpujari.
No, my lord, how my lord?
No, I appreciate it. I
How
appreciate
the
your effort of showing me how it has come.
Yes.
But I'm distinguishing it by saying that
it is his own land.
Yes.
So Article 300A, definitely at the end of that submission will come. I know.
And more so because you see, those decision itself clarifies what royalty is.
Yes.
Ultimately, royalty is for use of a land.
Use of a land.
Correct.
Right.
Now, when it is his own land,
Own
why
land.
should he pay any money?
Yes. So therefore, what was the?
I understand
What
when
was there in the
case
mind of
where
the?
the government land is being misused.
Absolutely. Absolutely.
There I understand.
Yes. Now here, my lord, it may be a solitary case
Because in those cases, government may have come up with a decision that instead of going on and evicting these people who have converted government land and are using it for manufacturing brick kiln, instead of doing all that, let us impose a royalty.
Royalty. Now, yes. So, my lord, what was there in the mind of the state? This is how it gradually developed. Things. Therefore, my lord, 103. Now,
Come
this
to
has
103, yes.
it has now taken a turn.
Yes,
Lordship will
Patta
find-
land. Yes.
I am directed to say that it has come to the notice of many people have set up brick industry on their own patta land and on Sarkari and reserve land. Since brick kiln is an industry, apart from royalty at the rate of 2.50 per cubic meter, land revenue at the rate of 10 times of the highest rated class of the land, that is Bahbari, should be assessed. In case of patta land, assessment will be treated normal land revenue, and in case of Sarkari land where industry has been set up with the permission of PB revenue for town land trade site rate should be applied. So they are using it. Now this notification, this letter was
For a moment, madam, clarification for this. What it says, madam, as because it is an industry, so revenue will be added enhanced. But otherwise, the royalty 2.50 per cubic meter of that brick art, not only industry.
Yes. Now
It has come to the government may set up brick on their own patta land and on Sarkari and reserve land. Since brick kiln is an industry, apart from royalty at the rate of rupees 250 per cubic meter, that is brick art, land revenue at the rate of 10 times of the highest rated class of land in the village, that is Balbari should be assessed. This is under that particular act.
I am not following this, the object here, how suddenly the Patta land has come. Because the letters prior to this only refers about misuse of government land and using of government land for agricultural purpose for
yes, my lord, here lordship will find a subject, my lord, page 103 itself, fixation of rates of revenue for land which is utilized for big industry. Now, my lord, if this is calculated 2.50 per cubic meter, the amount will be much higher. The amount will be much higher. So therefore, my lord, the next notification was issued in the year 2001. Kindly see.
Yes.
Settlement of land for bricklings and payment of royalty thereof. I am directed to say that the government have reviewed the instructions issued earlier in connection with so-and-so. The revised instructions shall now supersede all other earlier ones, so-and-so. Royalty, in addition to the land revenue to be assessed and realized as per section 25B of Assam Land Revenue Reassessment Act, Rule 16 frame, their royalty for art of bricklaying shall also be paid to the DC at the commencement of the season. So, land revenue, there is a special legislation. Its royalty is in addition to that. A minimum of rupees 12,000 per year shall be paid as royalty for producing bricks up to 4 lakhs number. Additional amount of 3,000 per year shall be paid for subsequent. Any person intending to set up brick lane must intimate a DC SDO by 30th September of a particular year, giving full particulars. Then, my lord, the next page, settlement of land for brick lane. These are the conditions, my lord, how a brick lane is going to be settled.
Yes.
Then, my lord, this litigation came. This litigation, my lord, which lordship has been, because there was an interim order at one point of time. In that, my lord, in WPC 3536 of 2002, there was an interim order. Lord, that lordship will find at page 108.
When can you have the written argument submitted?
My lord, next Monday I can give it, my lord. Today it may not be possible.
My lord, perhaps this matter would require little detailed hearing, my lord.
What more?
Because we are going here and there, my lord.
No, but one thing is very clear, Mrs. Aikya. You have been a member of an association. The association,
yes,
before the
in fact, that is the
considered
comment of time.
and said, all right, 10,000 we are agreeable. And on that basis, the notification has come for giving it 10,000. Now you again come and put a challenge, where is the source, where is the power? But you yourself have conceded. Once conceded, how can you reopen these issues? How can you contest it?
Therefore, my lord, I am paying your lordship for more time, my lord. Because, my lord, all along...
fixed on, list again on, did you? 10th of June.
Can you be on 13th, my lord?
All right.
13th of June. Because I cannot travel beyond the record.
No, Mr. Gorpujari, the thing, what happened is that as of now some clarity has come.
Yes.
Again after 13 June, I don't know. Because so many matters in between keeps coming. It's not possible for us also to remember.
I'm ready to go right now also,
No, it's all right.
but I think Lordship is rising, so therefore I wait for a longer time. Lordship, I take up, my lord.
The written submission in the meantime,
yes,
on that day you please hand it over.
Yes, madam.
Mrs. Aika, you also give your written
I
submission.
am committed to continue. Actually, I had the impression Lordship
No, that's all right.
wanted to
You give
rise.
the written submission so that we can conclude the hearing on 13th.
Yes,
All
definitely.
right?
Definitely.
Because next 2 weeks anyway, I'm not going to be
Definitely, my lord.
In station here. Parties are at liberty to submit their written arguments on the next date of listing.
Yes, definitely, madam. This will be my case. I cannot improve anything.
You just sequence-wise just place it them.
Absolutely.
So it will be easier for the court also to
Absolutely.
appreciate.
Absolutely. I'm so obliged.
May I please, Your Lordship? My Lord, this I is for correction of a typographical error, my Lord.
What is the error?
My Lord, in the last page of the order, my Lord, the date has been wrongly recorded, my Lord. My Lord, instead of 13th, it has been recorded as 12th, my Lord.
13?
13th, my Lord.
It has been referred as 12.
Yes, ma'am.
It should have been 13.
Yes, ma'am.
Very difficult. কোনে কৰিছিল বাইটো চাই লবচোন টাইপটো heard the respective councils. This is an interlocutory application seeking correction of the typographical error that has cropped up in the order dated 17/5/2024 passed by this court in WPC number 2561 of 2022. Stop. It appeared
2024, ma'am.
Now you see what you have typed. What have you typed?
There has been an error.
What have you typed?
2022.
See, this is also the reasons perhaps for which wrong things goes into the orders.
Even their cost.
Where do you think this court is going to dictate the order from? From the facts that you are writing. In cost title, you are writing it 2022. 2024?
Yes, sir.
2024. It appears from the order dated 17/5/2024 that in the last paragraph the order dated 12/3/2024 is inadvertently mentioned, whereas it ought to have been 13/3/2024. Stop. Accordingly, it is provided that the order dated 12/3/2024 in the order dated 17/5/2024 shall now be read as 13/3/2024.
Well,
stop. Allowed. Disposed of.